All participants who are gathered outside, please come inside the auditorium and occupy your seats. We welcome Shri Prashant Singh, Honorable Advocate General State of Madhya Pradesh. Those standing on my left, all participants, please occupy your seats. Please occupy your seats. All volunteers for today's program, please take your positions. Please take the assigned positions. All volunteers. Please take your seats. All volunteers, please take your respective assigned places. And those standing on my left may please take your seats. The Honorable Chief Guest and other guests of honor are just about to come. The program will start within 5-10 minutes. All volunteers for today's program, please take your assigned seats. All volunteers. Please don't gather in the galleries. And who will do this session? Vote of thanks.
This particular inauguration. We'll ask the chairman.
Do we have any other member also from?
It takes 3-4 minutes, so it's wonderful. Huh?
That's right.
Supreme Court judges come. Shall you see now?
Friends, our chairman, Mr. Manan Kumar Mishra, vice chairman, Mr. S. Prabhakaran, our member from Madhya Pradesh, Mr. Pratap Mehta, Mr. Suresh Chand Shrimali from Rajasthan, Mr. D.K. Sharma from Uttarakhand, Mr. D.K. Patel from Gujarat, Mr. Shailendra Dubey from Chhattisgarh, Mr. Pratap Singh from Punjab and Haryana, Mr. Apurv Kumar Sharma from Assam, Mr. Vishnuvardhan Reddy from Telangana, Mr. Shirnath Tripathi from UP, Mr. Pratap Mehta, Mr. Amit Vaid from Himachal Pradesh. We all welcome the honorable guests who have come here to participate in this program, which is of great interest. And it's a debate which is going on this particular issue which we have chosen for this symposium. ये बहुत ही सामयिक एक डिबेट होगा आज का जो सिंपोजियम है, particularly during and post pandemic 19, the issue has become very, very relevant and of great interest to the entire legal fraternity and as how this judicial system in the country is to run. And special thanks to our member Mr. Pratap Mehta from Madhya Pradesh for making this program possible in this swanky state of the art and beautiful auditorium. besides the inaugural session, we will have 3 more sessions till afternoon. So my request to all participants, particularly our advocates, young advocates, please stay till conclusion of all the 4 sessions. Friends, please welcome our honorable guest, Honorable Justice A.M. Khanwilkar, Chief Guest for today's function, Honorable Justice J.K. Maheshwari, Honorable Justice Ravi Malimath, Honorable Justice Satish Chandra Sharma, Honorable Justice Prakash Shrivastava, Honorable Justice Prashant Mishra, Honorable Justice Rajendra Menon, and all honorable judges and other guests. Please give a big hand to all the honorable judges, please. I request the Honorable Chairman Bar Council of India, Mr. Manan Kumar Mishra, Vice Chairman Mr. S. Prabhakaran, and other members Bar Council of India, please escort the honorable guest on the dais. Mr. Manan Kumar Mishra, Chairman Bar Council of India, Mr. S. Prabhakaran, please escort the honorable guest on the dais. नमस्कार, आपके साथ फ्लाइट में थे कल। नमस्कार, नमस्कार सर। प्रताप, आप इधर आइए, मेहता साहब, अपनी सीट। May I request you to please rise for the national anthem. Thank you. Good morning. A hearty welcome to you all from Bar Council of India to this symposium on courts technology and access to justice, changing perspectives. During pandemic and post-pandemic era, if there is one subject that has confronted and impacted all stakeholders in our justice delivery system, it is the use of technology in judicial ecosystem. Former Chief Justice of India, Justice S.A. Bobde, had said in his farewell address, I quote, access to justice now depends on access to technology, unquote. Technological transformation in the functioning of justice delivery system, which were brought about in the wake of COVID-19 pandemic, have received both praise and criticism. The theme of today's symposium was inspired by this ongoing debate and discussion. Friends, we start today's program with Saraswati Vandana by a group of young lawyers of the local bar of Indore.
या कुंदेन्दु तुषार हार धवला या शुभ्रवस्त्रावृता या वीणावर दंड मंडित करा या श्वेत पद्मासना या ब्रह्माच्युत शंकर प्रभृतिभिः देवैः सदा वन्दिता सा मा पातु सरस्वती भगवती निःशेषजाड्यापहा शुक्लां ब्रह्म विचार सार परमा आद्यां जगद्व्यापिनीं वीणा पुस्तकधारिणीम् अभयदा जाड्यान्धकारापहा हस्ते स्फाटिकमालिकां विदधतीं पद्मासने संस्थिता वन्दे तां परमेश्वरीं भगवतीं बुद्धिप्रदां शारदां बुद्धिप्रदां शारदां बुद्धिप्रदां शारदां
Thank you, dear friends, for the wonderful recital. Lighting of lamp removes darkness, ignorance, unhappiness. Lighting of lamp removes darkness, ignorance, unhappiness, and spreads God's grace, divine and energy in the surroundings. I now request the honorable guest on the dais to please light the lamp. Now, presentation of bouquets. I request the Chairman Bar Council of India, Shri Manan Kumar Mishra, to present a bouquet to the chief guest for today's program, Honorable Justice A.M. Khanwilkar, Judge, Supreme Court of India. I request Mr. S. Prabhakaran, Vice Chairman, Bar Council of India, to present a bouquet to Honorable Justice J.K. Maheshwari, Judge, Supreme Court of India. Shri Pratap Mehta, Member, Bar Council of India from Madhya Pradesh, will present a bouquet to Honorable Justice Ravi Malimath, Honorable Chief Justice, High Court of Madhya Pradesh. Mr. Vishnu Vardhan Reddy, Member, Bar Council of India from Telangana, shall present a bouquet to Honorable Justice Satish Chandra Sharma, Chief Justice, High Court of Telangana. Mr. Apurva Kumar Sharma, Chairman, Executive Committee, Bar Council of India, will present a bouquet to Honorable Justice Prakash Shrivastava, Chief Justice, Calcutta High Court. Mr. Shailendra Dubey, Member, Bar Council of India from Chhattisgarh, shall present a bouquet to Honorable Justice Prashant Mishra, Chief Justice, High Court of Andhra Pradesh. Yours truly will present a bouquet to Honorable Justice Rajendra Menon, Chairperson, Armed Forces Tribunal, Delhi, and former Chief Justice, High Court of Delhi, my High Court. Now, all members, State Bar Council of Madhya Pradesh, please come to present this jumbo garland to the honorable guest. उनके नाम इसमें नहीं, कोई नहीं, बाद में आ जाएगा. नाम बताइए, नाम दीजिए.
मिस्टर
नाम बता दीजिए.
रामेश्वरी निकरा, सीनियर एडवोकेट, रश्मि ऋतु जैन, शैलेंद्र वर्मा, उस्मानी जी, विवेक सिंह, सुनील गुप्ता, अखंड प्रताप सिंह, जय हरडिया, राधेलाल गुप्ता,
they are all honorable members, State Bar Council of Madhya Pradesh. No, they will keep it holding. Yes, please come. Mr. Rajesh Vyas, Member, State Bar Council of Madhya Pradesh. Don't keep it on the shoulders. Thank you very much. Shri Suraj Sharma, President, and Shri Gaurav Shrivastava, Honorary Secretary,
सभी ऑफिस
and other office bearers of High Court Bar Association Indore shall present a bouquet to our chief guest, Honorable Justice A.M. Khanwilkar. Please come.
सीनियर एडवोकेट TN सिंह साहब,
Shri K.N. Singh, Senior
TN सिंह
Advocate.
साहब सीनियर एडवोकेट, इंदौर हाई कोर्ट। एडवोकेट जनरल है। एडवोकेट जनरल प्रशांत सिंह, वो बड़ी एडिशनल है। जबलपुर हाई कोर्ट अध्यक्ष वर्मा जी,
और कौन है वहाँ से? हाँ, प्लीज। Mr. Sanjay Verma, President, High Court Bar Association, Jabalpur. To Honorable Justice J.K. Maheshwari. Mr. Himanshu Joshi and Mr. Pushyamitra Bhargava, ASG and AAG respectively, shall present a bouquet to the Honorable Chief Guest, Justice A.M. Khanwilkar. Now I would request our Honorable Chairman, Bar Council of India, Mr. Manan Kumar Mishra, to deliver the welcome address.
Honorable Mr. Justice A.M. Khanwilkar Sahab, Judge Supreme Court of India, Honorable Mr. Justice J.K. Maheshwari Ji, Judge Supreme Court of India, Honorable Mr. Justice Ravi Malimath, Chief Justice, Madhya Pradesh High Court, Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Telangana, Honorable Mr. Justice Prakash Shrivastava, Chief Justice, Calcutta High Court, Honorable Mr. Justice Prashant Kumar Mishra, Chief Justice, High Court of Andhra Pradesh, Honorable Mr. Justice Rajendra Menon, former Chief Justice, Delhi and Patna High Courts, and Chairman, Armed Force Tribunal. I also welcome all the Honorable Judges of Madhya Pradesh High Court sitting of the dais, the Honorable Chairman and members of various state bar councils, office bearers of various High Court and other bar associations of Madhya Pradesh, Honorable colleagues in Bar Council of India, senior advocates, members of legal fraternity, young friends, dear students, media persons, ladies and gentlemen. Friends, Honorable Mr. Justice A.M. Khanwilkar Sahab, who is to inaugurate today's function, was enrolled as an advocate on 10th February 1982. He practiced on civil, criminal and constitutional sides before the subordinate courts, tribunals, High Court of Judicature at Bombay, on appellate side and original side. He also practiced thereafter exclusively in Supreme Court of India from July 1984. He was appointed as additional judge of Bombay High Court in March 2000 and was confirmed as permanent judge in April 2002. His Lordship was appointed Chief Justice of High Court of Himachal Pradesh on 4th April 2013, and he was appointed as Chief Justice of Madhya Pradesh High Court in November 2013 and was elevated to Supreme Court on 13th May 2016. It is Mr. Justice Khanwilkar who has held that courts should not determine which religious practice should be struck down and which not. While Aadhaar PAN linking is mandatory, banks and telecom companies cannot ask people to link their bank account and mobile number with Aadhaar. A few important verdicts are: you cannot blacklist people without notice to them. Notify overdue elections of Maharashtra local bodies within 2 weeks on delimitation existing before 11th March. This is the recent order. Courts exercising contempt jurisdiction cannot enlarge the scope of relief claimed in the main proceeding. In case the foreign contribution can influence national policy, the government is free to prohibit the acceptance of foreign aid. Honorable Mr. Justice Khanwilkar was the co-chairman of Legal Education Committee of Bar Council of India, while he was the Chief Justice of Madhya Pradesh High Court, and he will again be associated with Bar Council of India after July 2022. I, on behalf of the entire legal fraternity of the country, welcome you, sir, on this gracious occasion. Our chief guest today, Honorable Mr. Justice J.K. Maheshwari ji, Judge Supreme Court of India, was born on 29 June 1961. His Lordship graduated in Arts in 1982 and passed LLB in 1985, completed his LLM in 1991. His Lordship was enrolled as an advocate with the State Bar Council of Madhya Pradesh in November 1985. His Lordship was appointed as additional judge of the High Court of Madhya Pradesh on November 25th, 2005, and in November 2008, he was appointed as the permanent judge of this High Court. His Lordship was a part of various committees pertaining to betterment of administration of High Court of Madhya Pradesh and continued his good offices till October 6, 2019, when he became a judge of. On August 31st, his Lordship was elevated as the Judge of Supreme Court of India. His Lordship, this is important for us, His Lordship was a member of Madhya Pradesh State Bar Council since 2002 till elevation, and was the chairman of Disciplinary Committee Gwalior Bench and worked in various other committees also of Madhya Pradesh State Bar Council. During short span of 15 months as the Chief Justice of Andhra Pradesh High Court, His Lordship has disposed of more than 4,500 cases. It was the first High Court to hear the cases by virtual mode at that time. During pandemic, more than 94,000 cases were heard by Honorable Judge during the tenure of His Lordship, though the strength of Andhra Pradesh High Court at that time was only 20. As per the E-Committee report of Honorable Supreme Court, Andhra Pradesh High Court was the second High Court which heard the highest cases during the pandemic. Under the guidance of His Lordship, E-filing module was also developed for online filing of cases in Andhra Pradesh High Court and subordinate courts during the COVID-19 pandemic time. While he was the Chief Justice of Andhra Pradesh High Court, he ordered contempt proceeding against social media. This was a bold decision. During COVID, when government decided to defer the payment of salaries to employees, your Lordship took suo motu notice of this serious issue, came to the rescue of poor employees of Andhra Pradesh. As a judge of Supreme Court, you have delivered several important judgments in a very short span of time. When there was a clash of date, you stayed the Judicial Service Exam of Haryana. Plea for judicial vista is logical, your Lordship has opined. On the point of disclosure of victim's identity under Section 23 of POCSO Act, there was a difference of opinion between your Lordship and other senior judge. Section 122 CRPC can be exercised. A man violating the conditions of bond can be arrested. This is the verdict given by Honorable Mr. Justice Maheshwari ji. Film Gangubai, a very important verdict. Mere hurting of sensibilities is not defamation. Your Lordship refused to stay the release of this film. Prevention of Corruption Act, Section 17A, is not retrospective. I request the honorable gathering here to give a big hand to the son of the soil. I welcome you, my lord, on this occasion. Honorable Mr. Justice Ravi Malimath, the dynamic Chief Justice of High Court of Madhya Pradesh, was born on 25th May 1962 in one of the most respected families of Karnataka. His parental grandfather, late Justice S.S. Malimath, was a freedom fighter and a pioneer in the struggle for the unification of Karnataka. His maternal grandfather, late Dr. S.C. Nandimat, was an acclaimed scholar in theology, Sanskrit, and Kannada. He was conferred with a doctorate by the University of London on the subject theology of the Siva Gamaj. He dedicated his life to the cause of education and established various educational institutions in backward areas of northern Karnataka. He was an eminent professor and a principal who subsequently became the Vice Chancellor of Karnataka University. His father, late Dr. Justice V.S. Malimath, is recognized as one of the finest Chief Justice ever. He was an eminent Chief Justice of High Court of Karnataka and later on of Kerala. Justice Malimath graduated in Commerce from MES College, Bangalore, completed his law degree from Sri Runukacharya College of Law. Thereafter, he joined the chambers of Sri Shivraj Patil, the former judge of Supreme Court, and thereafter, he had practice in all fields of law such as constitutional, civil, criminal, labor, and service matters. He was appointed as an additional judge of High Court of Karnataka in February 2008 and as a permanent judge in February 2010. Many landmark judgments were delivered by him as a judge of the High Court of Karnataka from 18th February 2008 to 2nd of March 2020. He has delivered final judgments in 44,886 cases. Therefore, you can imagine how difficult it is to narrate or choose such landmark judgments from that book. I welcome you, sir, in this august function. Our guest of honor today, Honorable Mr. Justice Satish Sharma ji, the Chief Justice, High Court of Telangana, was born on 30th November 1961. He is former acting Chief Justice of Karnataka High Court. Previously served as Madhya Pradesh as a judge of Madhya Pradesh High Court, where he was appointed as additional judge in January 2008 and permanent judge in January 2010. His father, Dr. B.N. Sharma, apart from being an agriculturist, was also an eminent academician who served as a professor of Jabalpur University and as a vice chancellor of Barkatullah University. Mother Srimati Shanti Sharma was a principal in Maharani Lakshmibai Higher Secondary School and also worked as district education officer at Jabalpur before retirement. My Lord Mr. Justice Sharma secured degree of Bachelor of Science in the year 1981 with distinction in 3 subjects. He was awarded National Merit Scholarship for postgraduate studies. He did his LLB from Dr. H.S. University Sagar and was top of the class and obtained LLB degree in 1984 with 3 university gold medals. Justice Sharma was enrolled as an advocate on 1st September 1984, became one of the leading lawyers of Madhya Pradesh. In 2003, he was designated as a senior advocate by High Court of Madhya Pradesh at a very young age. And he practiced in constitutional service, civil, criminal matters in the High Court of Madhya Pradesh. Sir, recently you have felicitated a home guard, Ashraf Ali. You all might be knowing it. In a wrongful termination of service, reinstatement with continuity of service is a normal rule. Road tax and toll tax paid in the highway are not double taxation. In case of circumstantial evidence, judges should be very cautious. Accrued right of citizen cannot be taken away by a prospective amendment. Educational institutions are not establishment under Shops and Establishment Act. This is the verdict of Justice Sharma. I welcome you, sir, in today's function. We are obliged that you have spared your valuable time to attend this function. Honorable Mr. Justice Prakash Shrivastava, the Chief Justice, Calcutta High Court. Your Lordship was born on 31st March 1961. He was enrolled as an advocate in February 1987, and he practiced in civil, tax, and constitutional sides in Supreme Court of India. He was elevated as an additional judge of Madhya Pradesh High Court on 18th January 2008 and took oath as permanent judge on 15th January 2010. He was elevated as Chief Justice of Calcutta High Court on 9th October 2021, took oath on 11th October 2021. Arbitration agreement does not end by death of a party. It is enforceable against the legal representatives. This is his verdict. In Birbhum massacre, Your Lordship and his colleagues sitting on the bench, they were not satisfied with the investigation done by SIT, and he ordered for a CBI probe. I welcome you, sir. You are the son of the soil, and you have spared your valuable time. This august gathering is welcoming you. Honorable Mr. Justice Prashant Kumar Mishra, the Chief Justice High Court of Andhra Pradesh, was born on August 29, 1964 at Raigad, Chhattisgarh. He did his BSc and LLB degree from Guru Ghasidas University, Bilaspur. He was enrolled as an advocate on September 4, 1987, practiced law in District Court at Raigad and High Court of Madhya Pradesh at Jabalpur and High Court of Chhattisgarh at Bilaspur. He dealt with civil, criminal, writ branches of law. He was designated as a senior advocate by High Court of Chhattisgarh in January 2005. Mr. Justice Mishra has been the chairman of Chhattisgarh State Bar Council for a period of 2 years. He was appointed and co-opted member of Rule-Making Committee of Chhattisgarh Bar Council. He had been the Chancellor nominee in the Executive Council of Guru Ghasidas University, Bilaspur. He was associated with Hidayatullah National Law University, Raipur, and its ex officio member in the Executive Council. He served as the Additional Advocate General for the state of Chhattisgarh from January 26, 2004 to August 31, 2007, and thereafter as Advocate General for the state from September till his elevation as the Judge of the High Court of Chhattisgarh. He was elevated as the Judge of High Court in December 2009 and was acting Chief Justice of High Court of Chhattisgarh from 1st June 2021 to 11th October 2021. He was appointed as the Chief Justice of Andhra Pradesh High Court in October 2021. Subordinate courts should accept web copies of orders and judgments in order to avoid miscarriage of justice. The case decided by Supreme Court in Amresh Kumar versus State of Bihar was elaborately clarified by a bench presided over by His Lordship. I welcome you, sir, on behalf of the entire legal fraternity of the country in this august gathering. Our guest of honor today, Honorable Mr. Justice Rajendra Menon ji, the son of the soil. He was the Chief Justice not only of Delhi High Court, but before that he was the Chief Justice of Patna High Court. He was born on 7th June 1957, graduated in science from Government Science College, Jabalpur, under Rani Durgavati University, did LLB from NSE Law College, Jabalpur, in the year 1981. He started practicing law soon thereafter and was standing counsel for central government from 1991 till his elevation to bench, besides being standing counsel for several private and public sector undertakings like Southeastern Coalfields Limited, North Coalfields Limited, and several others. His Lordship took oath as Additional Judge of Madhya Pradesh High Court in April 2002, became permanent judge in March 2003. He was posted at Gwalior branch of this High Court till March 2008, when he got posted at principal bench of Jabalpur. He was also the acting Chief Justice of Madhya Pradesh High Court for few months. During his Lordship's posting at Madhya Pradesh High Court, he was associated with several administrative committees. He was elevated as the Chief Justice of Patna High Court on 15th March 2017. He was sworn in as the Chief Justice of Delhi High Court in August 2018, and today His Lordship is chairing the National Armed Forces Tribunal. You might be knowing, everybody who has practiced before His Lordship, that the word no is not there in his dictionary. Justice Menon Sahab, he is a part of our Legal Education Committee, the Legal Education Committee of Bar Council of India today. We welcome sir in this august gathering. अब कुछ वकीलों की बात कर लें, 2 मिनट का समय लेंगे सर. Sir, bar and bench are two wheels of a chariot. Being the leader of the Indian bar, it's my duty to convey the feelings of the bar on various issues to the honorable judges sitting here. Recently, in the joint conference of Chief Justices and Chief Minister, judicial system was elaborately discussed. But sir, our anxiety was, the anxiety of legal fraternity was, that in this joint conference, the advocates and their bodies were nowhere. Though I was invited by Honorable Law Minister, but I was only one advocate, single advocate present in Vigyan Bhavan on that day. Sir, bar is also integral part of judicial system. Why to keep such distance? Sir, Bar Council of India and State Bar Councils, we strongly protected and supported the collegium system when it was in danger during the Congress regime, 2012-13. But the collegiums do not consult, never consult, even informally to the bodies of the bar or the leaders of the bar while making recommendations for appointment. Sir, when deserving lawyers, judges, or chief justices, having caliber and merit, are ignored in the matters of elevation, it adversely affects the system. Sir, today appointments are very slow. Several names are pending even after reiteration by Supreme Court Collegium. But our Supreme Court appears to be helpless. We wish and we always stand for making our Supreme Court and High Courts stronger and fearless. Though some of the honorable judges, I must say, sir, you are the guardian of the system. Some of the judges of the High Courts, of some High Courts, they are very hostile to the Bar Councils. But Bar Council of India has always supported the honorable judges and the judicial system, you might be recalling. On every occasion, we have stood with the judiciary and we have tried to strengthen and make it more stronger and stronger. Sir, in Nalsa, the lawyers, the Bar Councils and Bar Associations have, as per the major opinion of the legal fraternity, have absolutely no role to play. This is becoming a big reason for resentment of lawyers throughout the country. Increasing ADRs and now move of mediation are neither for benefit of lawyers nor for litigants. The burden of courts are not going to decrease. We want the existing vacancies to be filled up and sanctioned post of judges at all levels to be increased. I am placing all these things before Honorable Mr. Justice Khanwilkar Sahab because I know about his boldness and everybody knows that he is the man of independent thinking and he is a well-wisher of the bar, a bar-friendly judge. While his lordship was the Chief Justice of Madhya Pradesh High Court, he introduced the new reformative system of listing and the system was for the benefit of the bar. Even the Madhya Pradesh bar, the High Court bar also realized this fact after some time. Therefore, we are sure that his lordship can convey our feelings to the concerned people and will do the needful. In order to improve the standard of legal education, the Bar Council of India, through its trust, is establishing an international law institution which would be a world-class law school. All the dignitaries sitting on the dais would be a part of this new and unique law school. Honorable Chief Justice of India is the Chancellor. Admission tests are very soon going to be held. The sitting and former judges, senior and experienced advocates and jurists of India and abroad would be the guest teachers in this international school. Sir, today we are going to discuss a very important topic, courts, technology and access to justice, changing perspectives. This subject has a direct bearing with the career and future of every lawyer and the entire legal system. This symposium would prove very fruitful and country would be benefited from the valuable speech to be delivered by honorable dignitaries on the dais in the technical sessions. The Bar Council of India is grateful to Honorable Mr. Justice Khanwilkar Sahab, Honorable Mr. Justice J.K. Maheshwari Sahab, and other honorable dignitaries on the dais and off the dais for sparing their precious time to grace this occasion. I welcome you all. Jai Hind, thanks, namaskar, pranam to all.
Thank you, Chairman, for your stimulating speech and raising very, very important issues which have caught the imagination of all of us And I hope in future the entire legal fraternity will sit down and put their head together to address so many issues which have been raised by Mr. Manan Kumar Mishra. Now I would request Honorable Justice Rajendra Menon, Chairman Armed Forces Tribunal and former Chief Justice Delhi High Court, to deliver his address.
A warm good morning to each and everyone. Honorable Justice Khanwilkar, Judge, Supreme Court of India, my esteemed brother, Justice J.K. Maheshwari, Judge, Supreme Court of India, Chief Justice Ravi Malimath, as described by the Chairperson of the Bar Council, the dynamic Chief Justice of the state, and as a member of the bench with him, I endorse it as I agree. Justice Satish Sharma, Justice Prakash Mishra, Justice Prakash Shrivastava, Justice Prashant Mishra, my esteemed brother judges from the Madhya Pradesh High Court and presently Chief Justices of various High Courts, Shri Manan Mishra, Chairperson, Bar Council of India, Mr. Prashant Singh, Advocate General of the State of Madhya Pradesh, Judges of the Madhya Pradesh High Court, members of the Bar Council of India, State Bar Council of Madhya Pradesh, advocates, students, ladies and gentlemen. Courts, technology, and access to justice, changing perspective is the theme of today's symposium. And choosing Madhya Pradesh for this symposium under the guidance and leadership of Justice Khanwilkar adds 4 feathers to the symposium. I can vouch it with authority that Madhya Pradesh High Court, under the leadership of Justice Khanwilkar, entered into the area of introducing technology to the courts way back in 2013. And today, if we go and see the working of technology in various high courts, including the Supreme Court, you would find that it is the same pattern that was introduced by Justice Khanwilkar in Madhya Pradesh, which is being followed in most of the high courts now. That being the factual position, there could not be a better place than Madhya Pradesh and a better person than Justice Khanwilkar to be amongst us to address us on this issue. Technology is something which we cannot say that we don't want. I can say that at one point of time, the members of the bar had great reservation in the manner in which technology was introduced into the system. We need not discuss the part, but the pandemic made everybody change their thinking, and the pandemic prepared us all to accept technology as a part of our system. And today, most of us have accepted technology as a part of our system and have come to the conclusion that we cannot continue further or go for betterment of the system without technology. Artificial intelligence is one of the technology which forms a unit in this technological innovation, and we in Madhya Pradesh have experimented with it in the matter of generation of automatic notices and various other systems, and which has proved to be beneficial. I am involved in various activities pertaining to the defense, and during one of my visits to the naval units in Mumbai, I was introduced to an artificial intelligence technology where a research is going on to operate a ship without a captain by use of artificial technology. That is where the world is proceeding. Can we think of being far back from them? Therefore, technology has to be adopted in our system also. But how, to what extent, in what manner, what are the difficulties that we'll have, what are the remedies for those difficulties, are the issues which should be discussed in such symposium. I'll not dwell much into the subject, but leave it to the experts and the members of the August gathering to discuss it during the course of the day. But I would say one thing for the benefit of the members of the bar. With my experience for the past 2 years as a member of a tribunal, I have a tribunal which has 10 benches. And out of the 10 benches, 8 benches are non-functional because of non-appointment of members. And I get representation from the members of the benches that cases in their benches are not being heard. The statutory provision for transfer of cases from those benches to the principal bench is being undertaken. As a result, the members of the bar of those benches are suffering. I was faced with this situation when, for good or bad, the pandemic came and the system of virtual hearing started. And today, even without members in the benches, all my 10 benches are functioning by virtual hearing. I sit in Delhi and hear cases of all the benches. So that is the advantage which I could give to the members of this bar by use of technology. So my dear friend advocates, please accept the technology, be prepared to accept the technology, and let us move forward together. I would not take much time. We'll discuss those issues in detail when we come to the session. I would like to thank the Bar Council of India and the State Bar Council of Madhya Pradesh for having graciously invited me for this function. It was a pleasure coming back to Indore after 6 years. Thank you very much. Jai Hind, Jai Bharat.
Sir, thank you very much for this great presentation and for raising the issues about the plight of litigants and lawyers who are suffering because of absence of presiding officers on various benches. Now I would request Honorable Justice Ravi Malimath, Honorable Chief Justice High Court of Madhya Pradesh, to address the gathering.
Khanwilkar, Judge Supreme Court of India, Honorable Chief Justice J.K. Maheshwari, Judge Supreme Court of India, Honorable Chief Justice Satish Chandra Sharma, Chief Justice High Court of Telangana, Honorable Chief Justice Prakash Shrivastava, Chief Justice High Court of Calcutta, Honorable Chief Justice Prashant Mishra, Chief Justice High Court of Andhra Pradesh, Honorable Chief Justice Rajendra Menon, Chairperson, Armed Forces Tribunal, New Delhi, and former Chief Justice of the High Courts of Delhi and Patna, my esteemed brother judges from the High Court of Madhya Pradesh, Shri Manan Kumar Mishra, Senior Advocate and Chairman, Bar Council of India, Shri Pratap Mehta, Convener and Member, Bar Council of India, Madhya Pradesh, Shri S. Prabhakaran, Senior Advocate and Vice Chairman, Bar Council of India, Shri Apurva Kumar Sharma, Senior Advocate and Chairman, Executive Committee, Bar Council of India. Shri Prakash Sharma, Co-Chairman, Bar Council of India. Shri Prashant Singh, Learned Advocate General, and his team of judicial officers, the judicial officers of the state of Madhya Pradesh, the former judges of the High Court of Madhya Pradesh, the chairman and vice chairman and members of Bar Council of the various states of the country, ladies and gentlemen, a very good morning to all of you. It is my pleasure to be here today at the Symposium on Courts, Technology and Access to Justice, Changing Perspectives. Technology and access to justice are both integral to the justice delivery system. While access to justice is one of the fundamental tenets of the legal profession, technology is what helps in reaching this goal in an efficient and speedy manner. Ensuring access to justice is different from securing justice. Access to justice constitutes the first step towards securing justice. The latter is what is expected to happen down the line post-filing of the wakalat, but the former involves everything that needs to be undertaken to give an aggrieved person the confidence to file the wakalat in the first place. There are certain aggrieved people who are unaware of their rights, some who do not have the resources to fight for their rights, and some who are weary of the courts and the advocates. To resolve each one of these challenges such that they are confident enough to approach the courts and demand justice embodies the access to justice. Access to justice and courts technology are two sides of the same coin. Good technological infrastructural facilities access to justice and ensures the delivery of speedy justice. A decade ago, the words court and technology were deemed to be antonyms with each other. The typical image that would come to mind when one picturized a court is that of stacks of paper with everything being done manually and there being no room or use for computers. This has now changed for the better. Computers and technology are being utilized to a great extent in the day-to-day functioning of the courts, and they have become indispensable. The High Court and subordinate courts at Madhya Pradesh are undoubtedly the leaders when it comes to technological infrastructure in the country. The pioneer of such technological advancements in the courts at Madhya Pradesh is Honorable Justice Shri A.M. Khanwilkar, Judge, Supreme Court of India, who has graciously joined us on this occasion in spite of his very busy schedule. The work that was undertaken by His Lordship during his tenure as the Chief Justice of Madhya Pradesh are tremendous. Certain technological related initiatives by him are introduction of a computerized listing policy, e-cause list and development of the case management information system software for better court management, installation of multi-protocol label switching network for providing a high-speed dedicated network to all the district courts of Madhya Pradesh, introduction of the interactive voice response system for provision of status of case and other information to the stakeholders, development of varied software, including an in-house software for RTI applications, digitization of High Court records in view of the environment, introduction of the inter-office voice conferencing system for facilitating quick audio-visual communication between the registry, procurement of journals in soft copy and modernization of the High Court library, installation of the digital display system for dissemination of case-related information and GPS-based digital clocks to ensure accuracy of time across the court, creation of and obtaining sanction of almost 260 IT cadre posts for the High Court and the district courts, creation of the online employee information system and the biometric attendance and monitoring systems. These are only some of the countless innovative and forward-looking technological infrastructures introduced by Justice Khanwilkar. It is also important to acknowledge that the transition to the virtual mode as a result of the pandemic was relatively smoother in Madhya Pradesh, since the backbone infrastructure had already been put in place by Honorable Justice Khanwilkar, who had established video conferencing facilities in the High Court for effective communication with judicial officers across the state. His Lordship had also undertaken extensive work pertaining to the physical infrastructure of the courts at Madhya Pradesh, such as the construction of new buildings of the Judicial Academy at Jabalpur and Gwalior, infrastructure for additional court halls, and construction of the district court complex and various courtrooms across the state. Apart from the technological and physical infrastructure, His Lordship had tireless work for the betterment of the judiciary of Madhya Pradesh. The judiciary and all the stakeholders of the justice delivery system are indeed grateful to you, sir, for the immense work undertaken by you for the cause of justice. We are also fortunate to have with us Justice J.K. Maheshwari, Judge Supreme Court of India, who has kept the flag of Madhya Pradesh judiciary flying high. Justice J.K. Maheshwari worked as a judge in the state of Madhya Pradesh for many years, and there are numerous actions undertaken by His Lordship for the development of the High Court and subordinate courts at Madhya Pradesh. He has undertaken multiple initiatives, including upgradation and continued monitoring of infrastructure in courts across the state, setting up our court halls at the High Court of Madhya Pradesh, provision of new vehicles for the judges of the High Court and the district judiciary, development of various district courts in Madhya Pradesh. His concern for the litigants was evident in the various initiatives undertaken by him, such as providing seating arrangements and water coolers for the litigants in all the districts and tehsil courts in the state of Madhya Pradesh. We are thankful to you, sir, for all that you have done for the Madhya Pradesh judiciary. We are obliged to have with us Justice Rajendra Menon, Chairperson, Armed Forces Tribunal, who had the distinct honor of serving as the acting Chief Justice of his parent High Court, the Madhya Pradesh High Court, before being elevated as the Chief Justice of the Patna High Court and thereafter as the Chief Justice of the Delhi High Court. Justice Menon undertook several initiatives, such as setting up of computer server rooms and judicial service centers at court complexes right across the state, undertaking continuous training of judicial officers, including with respect to computers, setting up of the network management system for the High Court and district courts in order to monitor the functioning of network and related devices, establishment of the process generation and delivery system software, complaint management system, statistical work software, and other such software with a view to streamline essential actions. We are thankful to you for you, sir, for all that you have done for the Madhya Pradesh judiciary. We are also glad to have with us Justice Prakash Shrivastava, Chief Justice, High Court of Calcutta, Justice Satish Chandra, Chief Justice, High Court of Telangana, and Justice Prashant Mishra, Chief Justice, High Court of Andhra Pradesh. The honorable judges have all contributed greatly over the years to the judiciary, and we thank them for the same. I congratulate the Bar Council of India for conceptualizing and organizing this symposium on courts, technology, and access to justice, changing perspectives. The theme chosen for the symposium indicates that the advocates are as enthusiastic as the judges to employ technology for increasing access to justice and for furthering the cause of justice. A few months ago, we had conducted a training program for advocates on various topics which have received an overwhelming response. We would be happy to organize similar programs with a focus on technology, if desired by the advocates. I hope that this symposium will provide the advocates with some food for thought and wish the advocates the very best. Thank you.
Sir, thank you for the highly informative and inspiring address. Now I would request Honorable Justice J.K. Maheshwari, Judge Supreme Court of India, to address the gathering.
A cordial good morning to everyone who are present in this August gathering. Justice Khanwilkar, sir, Honorable Judge, Supreme Court of India, Justice Ravi Malimath, Honorable the Chief Justice of Madhya Pradesh High Court, Justice Satish Sharma, Honorable the Chief Justice, Telangana High Court, Honorable Justice Prakash Shrivastava, Chief Justice, Calcutta High Court, Justice Prashant, Mishra, Honorable the Judge, Chief Justice of Andhra Pradesh High Court, Justice Rajendra Menon, Chief of the Armed Forces Tribunal, Mr. Kumar Mishra, Chairman Bar Council of India, Prakash Mehta, Member Bar Council of India from Madhya Pradesh, Sri S. Prabhakar, Senior Advocate and Vice Chairman of the BCI, Sri Kumar Sharma, Senior Advocate and Chairman Executive Committee Bar Council of India, Sri Prakash Sharma, Co-Chairman Bar Council of India, Honorable the Judges of Madhya Pradesh High Court, sitting and former Advocate General of the State of Madhya Pradesh, Shri Prashant Singh Ji, District and Sessions Judge, Indore and other districts, administrative officers of the district administration, Collector District Indore, Commissioner of Police Indore and other officers present, respected senior members of the bar and number of the students who are present. Welcome to all of you. It's my pleasure whenever I am coming to Madhya Pradesh. It's always my pleasure. But when this conference was organized by the Bar Council of India, Mishra ji and Pratap Mehta ji contacted me to be here. And I said, it's my pleasure whenever I am in Madhya Pradesh, in any of the city. Friends, we know today's topic is courts, technology and access to justice, changing perspective. I will share some experiences which when I started my practice, because some students are here and they would understand why this changing perspective is necessary. Friends, we know there can be no equal justice without equal access to justice. Would access to justice only apply to the courts? The access to justice starts first from police authorities, local administration. As I know, in Madhya Pradesh, they developed so many applications for this purpose. As we know, one of the well-known application is Citizen Cop for the safe side of every citizen, that includes of the children. But when coming to the court, why changing perspective issue is required to be discussed now today, why not it was earlier? When I started my practice in 1985, I was aware that whenever a petition or a second appeal is filed, how first it is to be written in handwriting, typed, filed, and whenever any certified copy is required to be taken, you know, you have to search out a person who will write in handwriting, or otherwise a person who can type and then provide you the certified copy. Here from the court's technology started in access to justice. Now in these days, if you say how we can get a certified copy of the order, how we can file a writ petition, that everything is online and you can go and file. This is a changing perspective, use of technology in access of the justice. I remember when this pandemic was started, I was in Andhra Pradesh at that time. It was declared on 20th March 20, court closed, everything closed, curfews. How in courts petitions can be accepted, how the hearing can be possible. For some time we have worked out, and we find out one way in Andhra Pradesh. I discussed with my Registrar General, who are the judicial officers, and some officers, IT officers were there. Then on June application we started, first hearing on 27th of March. But at that time, how the application can be filed, how a petition can come to the court. Staffs were not coming, court functioning was hampered completely. Then we remember, the e-court functioning, is it real, or what are the deficiencies remain which is required to be updated? You can see from that point of time and present within 2.5 years. In entire country, not only in the state of Madhya Pradesh, Supreme Court, High Court, and all subordinate courts are functioning on virtual mode. If this technology advancement or technology development was not there, the dream of access to justice cannot be achieved. If we see about Madhya Pradesh and looking to the topic, Justice Menon has rightly said that it is Justice Khanwilkar, during his time, this technology advancement and how we have to develop the e-court project, which was in 3 phases, ought to be started, and it was started at that point of time in practical way. I am not saying it was not there. You know, at present the Madhya Pradesh High Court and the subordinate courts in India is on the highest position, and they have achieved all the system at the top level in the graph. So now this is the technological advancement in access to justice. Friends, we have to do more. हमेशा you have to understand one thing. Whenever any change start, the practical aspect I am telling you, suppose Justice Menon has decided to do something, to the others, what they will do? Their reaction remains, first they will laugh on him. He is doing like this. Why? If they not succeed in that, then what they do? Then resentment, opposition. And when they could not succeed in these two, then they accept whatever he is doing. And the same situation has done in Madhya Pradesh, which I am remembering. Whenever the technological advancement was started, these three phases I have seen from my eyes. I was the judge in Madhya Pradesh High Court, I know. But today, we are not supposed to say anything. We have to listen from your mouth whether by your technological advancement in access to justice, are you happy or not? If you are happy, friends, we have to do more and continue to do the advancement of the technology, thereby the people may reach up to high destination of access to justice. Thank you very much.
Sir, thank you very much for the highly encouraging and motivating address. Now, for today's program, we have participants and leaders of the state bar councils from different states. I would request them alphabetically to please come and present bouquets to our honorable guest on the stage. Mr. V. Brahma Reddy and Mr. K. Venkata Rami Reddy from Andhra Pradesh. Please come. Please present bouquet to Honorable Justice A.M. Khanwilkar. Please come. Then State Bar Council leaders from Bihar, Mr. Jai Prakash Singh, Mr. Pankaj Kumar, Mr. Arun Kumar Singh, Mr. Deenanath Yadav, Premnath Oja, Arun Kumar Pandey, Vindhya K. Hari Kumar. Please come. From Bihar, to Honorable Justice J.K. Maheshwari. From Chhattisgarh, Mr. Rahul Mishra, Mr. Pawan Sharma, please come. And thereafter from Gujarat, then Jharkhand. Be ready. Please come, Mr. Rahul Mishra, Pawan Sharma. Honorable Justice Ravi Malimath, please. From Gujarat, Mr. S.S. Gohelji, Mr. Kishore Kumar Trivedi. From Gujarat, Mr. Patel, you may come please. Mr. Patel, Dalip Patel, BCI member from Gujarat. Ravi, Justice Satish Chandra Mishra. From Jharkhand, Mr. Rajesh Shukla. Please come. And thereafter Karnataka, Rajesh Shukla ji. Please present a bouquet to Honorable Justice Prakash Shrivastava. Karnataka, Mr. Kashinath Chairman, Mr. Chandra, Mr. Harish. Please present a bouquet to Justice Prashant Mishra. From Manipur thereafter, please be ready. Manipur and then Rajasthan. From Manipur, Mr. Jitendra Singh, please come. Mr. Saroja Yomnam. To Honorable Justice Rajendra Menon, please. And from Rajasthan, Mr. Sachin Sharma, Mr. R.P. Singaria, Mr. N.S. Chaudhary. To Mr. Manan Kumar Mishra, our chairman. And from Tamil Nadu, Mr. Amal Raj, Mr. V. Karthikeyan, Mr. Marappan, Mr. Ayyabur, please come. State Bar Council leaders from Tamil Nadu, please come. Honorable Justice A.M. Khanwilkar, please present a bouquet to Justice A.M. Khanwilkar. From Telangana, Mr. Anand Sen Reddy, Mr. K. Sunil God, Mr. K. Shalini, Miss K. Shalini, please come. The delegation from Telangana. Please present a bouquet to Honorable Justice J.K. Maheshwari, Telangana. And Uttar Pradesh, Mr. Shirish Kumar Mehrotra, Mr. Rakesh Pathak. ये कौन?
उत्तर प्रदेश में
नहीं, उत्तर प्रदेश मिस्टर शिरीष कुमार हो गया, मिस्टर राकेश पाठक आ रहे हैं। जस्टिस रवि मलिमथ, प्लीज। उत्तराखंड, राव मंतफेत अली। Then Mr. Prashant Singh, Advocate General, Mr. Ankur AAG, please. Justice Ravi Malimath, Justice Ravi Malimath. Mr. Prashant Singh, please come. And Mr. Ankur, please come. And Mr. A.S. Sirpurkar, please be ready. Honorable Justice Khanwilkar. Mr. A.S. Sirpurkar. To Honorable Justice Khanwilkar. now our members from Bar Council of India. They are to present memento and shawl to our honorable guests. I request Mr. Manan Kumar Mishra and S. Prabhakaran to present a memento and shawl to Honorable Justice A.M. Khanwilkar. Mr. Manan Kumar Mishra and Mr. S. Prabhakaran presenting memento and shawl to Honorable Justice A.M. Khanwilkar. Mr. Pratap Mehta and Mr. Suresh Chand Shrimali, please come. Shrimali ji ko aane do. Pratap Mehta and Suresh Chandra Shrimali to Honorable Justice J.K. Maheshwari. Mr. D.K. Sharma and Mr. D.K. Patel. Please present memento and shawl to Honorable Justice Ravi Malimath, D.K. Sharma ji and D.K. Patel. Mr. Shailendra Dubey and Pratap Singh, please you also come. Shailendra Dubey ji and Pratap Singh to Honorable Justice Satish Chandra Sharma. Apurva Kumar Sharma and yours truly to Honorable Justice Prakash Shrivastava.
Mr. Vishnu Vardhan Reddy and Mr. Srinath Tripathi. Mr. Vishnu Vardhan Reddy and Mr. Srinath Tripathi to Honorable Mr. Justice Prashant Kumar Mishra ji. Mr. Pratap Mehta and Mr. Amit Vaid, please come. Honorable Justice Rajendra Menon.
Friends, we are extremely grateful to Honorable Judges of Madhya Pradesh High Court who have come today to participate in this program, to grace this program. Now I would request Honorable Chairman, Bar Council of India, Mr. Manan Kumar Mishra, to present a bouquet to Honorable Justice Vivek Ruzia. Mr. Apurva Kumar Sharma to Honorable Justice Vijay Kumar Shukla. Apurva ji, please, Apurva ji, please come here, this side. To Honorable Justice Vijay Kumar Shukla. Mr. Amit Vaid, please present a bouquet and shawl to Honorable Justice Subodh Abhyankar. Mr. Pratap Singh to Mr. Justice Anil Verma. Mr. D.K. Sharma, please present a bouquet and shawl to Honorable Justice Satendra Kumar Singh. Mr. Srinath Tripathi to Honorable Justice Rajendra Kumar Verma. Mr. Patel to Honorable Justice Pranay Verma. Mr. Vishnu Vardhan Reddy to Honorable Justice Amarnath Keshavani. Mr. Pratap Mehta ji to Honorable Justice Anand Pathak. Mr. Shailendra Dubey to Honorable Justice Vivek Agrawal. Vishnu Vardhan Reddy ji to Honorable Justice Virendra Singh. D.K. Sharma ji to Honorable Justice Purushendra Kaurav. Apurva Kumar Sharma ji to Honorable Justice Milind Ramesh. अपूर्वा कुमार शर्मा जी और सुरेश चंद्र शर्माली जी। Mr. Prashant Singh, Advocate General. Mr. Prabhakaran, please present a bouquet to Mr. Prashant Singh, Advocate General, Madhya Pradesh.
आइए, please take your seats.
Now I request our Honorable Chief Guest, Honorable Justice A.M. Khanwilkar, to deliver his address. Honorable Justice A.M. Khanwilkar.
Good morning, everyone. There's a long list of dignitaries. So should I follow the conventional path or start with my address straight? Is the predicament before me. The possibility of missing out someone is very imminent in such a large gathering. So I would be unconventional in a way. I will say dignitaries on the dais and off the dais, which includes everyone. Please accept this. I am really delighted to be here amongst all of you here at Indore. Perhaps after going to Delhi, this is my first visit here, and more so sitting with all the dignitaries on the dais here, my esteemed colleagues who were very dear to me when I was here. Being the last speaker in this inaugural session, my task has become somewhat difficult. I say so because the topic for discussion today and also for the inaugural session has been touched upon by the previous speakers. Nevertheless, I will endeavor to improve upon certain areas which I believe they have consciously left out to provide some space to me to interact with you. But before doing so, I must appreciate the arrangements made by the organizers for ensuring my comfortable stay here in Indore and to be part of this symposium involving judges, senior advocates, leaders of the bar, and other stakeholders on this day, which is being celebrated as Mother's Day in India, as an annual event in appreciation of mothers world over. Reverting to the topic, Mr. Mishra must be anxious to hear me on the comments he made, but I am going to consciously avoid saying that in the beginning. Reverting to the topic earmarked for this symposium, courts, technology and access to justice, changing perspective, is in itself a pointer to have a dialogue about the contemporary situation and the way forward for the duty holders to serve the larger cause of justice. Justice for all, I would say. The solemn duty of the court and all its benefactors is to ensure that speedy justice is dispensed equally to all without any exception. But before that, it is quintessential that there is inviolable mechanism to provide access to justice to all. When we speak about access to justice, it may posit different perspectives. To illustrate, denial of entry to the court of law on account of variety of reasons, including financial problems one must be facing. Here I am reminded of a famous quote from Magna Carta, and I quote, to no one will we sell, I repeat, to no one will we sell, to no one will we deny or delay right to justice. This is the core principle of access to justice for all. In one sense, undue delay in adjudication of disputes which have come in the court is also a form of denial of access to justice. The adage of delay defeats justice, or for that matter, delay entails in denial of justice, is so true. When we talk about changing perspectives, it also includes the changing pattern of litigation. As a student of law, you would realize that the kind of disputes or litigation filed few decades earlier are almost disappearing. Mr. Nikra would be testimony to that. He must have seen at least 3 decades, 4 decades of litigation and the pattern of litigation. There is a paradigm shift, not only the type of disputes, but the manner in which the same are proceeded with. With the changing times and advent of technology, the issues that arise for consideration are also different. Not too long ago, technological devices used by the courts across the globe were in the form of mere typewriters, at best audio systems and video recording. As the technology has evolved, there is a need to modulate the adjudicatory process as well. There are broad issues, these are broad issues which need to be discussed in this symposium. Over the past few decades, we as an institution have tried and to a large extent succeeded in consolidating public confidence regarding impartiality and integrity. With the piling dockets in courts and tribunals, the confidence of the litigants is bound to be shaken. That is being discussed and debated all over. That is not only because of low productivity and disposal in courts, but also because of human failings which result in manipulation of the processes. It is undeniable that the process of decision making by a judge cannot be supplanted by technology, be it by way of artificial intelligence, so long as the law does not exclude the process of appreciation of facts or weighing the equality in favor of one or the other party. The technology may help in processing of cases, including classification and for prioritizing the same. I can visualize only one such situation where the breach of traffic rules and the penal consequences, therefore, may be a matter dependent purely on technology and could be resolved by technological devices, such as the violation recorded in CCTV camera and the automated challans issued for such violation. However, when it comes to the defense of the accused, of disputing the admissibility of such evidence, there would be no other means of resolving the same but by producing the evidence before the court by both sides and consideration thereof by the court. This process cannot be taken forward until there is involvement of human mind and training for resolving such claims. In that sense, the technology is only a facilitator and cannot supplant the judicial or decision-making process. Much has been said and done for achieving justice for each and every individual in this country, regardless of one's faith, creed, caste, or sex. Right from the judges of the highest constitutional court to the various governments, efforts have been made to make it possible for a person to rightfully ask for free legal aid. Yet, on the eve of celebrations of 75 years post-independence, or so to say, Diamond Jubilee, many things have changed, and today the change seems to be posing new challenges. The pandemic has thrown open new kind of problems. In the same breath, it has also opened up opportunities and options. One such is the use of technology. My previous speakers have already emphasized about it, how technology helped them to resolve the crisis situation. Today, the internet has brought almost all information to our fingertips. All one needs to do is to take the initiative to surf through the humongous data available on the internet and have the ability to zero in on useful information. Anything and everything can be accessed with minimal effort, right from finding a competent lawyer in a specialized domain, online legal advice, online drafted legal documents, e-lok adalats, e-stamp paper, digital signatures, online legal research, language translation, all are available irrespective of one's physical location. Today, even with all the tools and all the steps taken, we need an objective standard of quality justice for the litigants and empower them in exercising an informed option. At this juncture, technology has progressed to such limits that we can truly realize the objectivity of transparency, which is a cornerstone in a true democracy. The mandate of Article 39A of the Constitution is better served and given a truly encompassing meaning when technology is added to its ambit. Information and communication technology has regained fervor post the COVID pandemic. E-lawyering has become a quintessential skill that all lawyers need to acquire expeditiously. A paradigm shift has been seen from the introduction of e-courts in 2007 in the era of artificial intelligence. Big data is the key to unlocking not only historic but futuristic course of arguments which might as well be original, quicker and more sophisticated than a single lawyer's legal tools. However, the same should not be seen as a hindrance to anyone. We need to push for future technologies such as edge computing, bring in data centers and elevate data security. We might also need to set up better electric and data connection or connectivity, as commonly known, in and around across the court complexes, the country, so that anyone and any person can use it very effectively. The resources such as this would really help in empowering the litigants themselves as well as the lawyer fraternity. The National Judicial Data Grid, which is already well placed, has many other horizons to explore still. USA had the case management electronic case files since 1990s, which has been employed for electronic filings and management of documents. There is an urgent need to rejig and motivate our future generations to be compatible with best practices from around the world for making India a truly developed country. It is also worthwhile to point out that efforts should not only be made to help litigants, but also for lawyers, judges, and all other stakeholders, as there is an inherent need to acquaint and empower the insiders in the profession. We can use and develop various tools such as this for research, drafting, educating as per our local requirement. Today, blockchain technology and non-fungible tokens, or NFTs as is commonly known, have taken the world by surprise. They obviously, like any other technology, have many pros and cons. Since we are at the incipient stage of these technologies, we need to exploit the same in the best possible ways at the earliest. There are many issues that surround online tech activity, such as forgery of documents, online frauds, hacking, etc. These issues can be addressed using blockchain, which essentially has many different aspects, which have still remained unexplored in India. The world is moving ahead with technology, and as the judiciary of the world's largest democracy, we cannot stay behind. Young lawyers have suffered with total virtual hearing all time. They were not able to interact with their clients in person or able to appear before the courts physically. Their work has taken a hit. I stand for innovation in technology for the courts, but also wish for it to continue in physical mode, subject to permission being given in special cases for virtual hearing, which can be beneficial to younger and senior members of the bar. Moving forward in this direction, I have few suggestions to make. Young advocates are suffering due to lack of work owing to this pandemic situation. We cannot expect them all to sit in a fancy office and appear before the court. This demoralizes the advocate who is fresh entrant in the profession. We must take steps to encourage the young advocates who are the future of our profession. With virtual hearings, the advocates must reduce the practice of seeking adjournments and further dates to reduce pendency of cases. Ensure that all the parties get virtual access to the cases before the court. The litigants are entitled to see what happens in their case. This helps them get a better understanding of the way ahead. In this automated world, allow e-copies of documents to reach advocates and judges before physical copies reach them. This helps save a lot of time of advocates as well as judges, and indeed, we would be assisting the cause of environment by saving paper. Late arrival of documents lead to last-minute reading, which isn't always thorough. Today, significant number of population of our country own a smartphone, which with access to internet. Taking advantage of this, lower courts as well as higher courts should be accessible to even the most remote parts of the country. The system of e-filing was introduced during the pandemic by the courts in India. This is a very positive step. The effort must continue, which will help in reducing long lines outside the filing counters. A software to identify the defects in the matter which is filed online should also be developed if need be, so as to rectify the objections and process the matter with speed. Mark Zuckerberg, the founder of erstwhile Facebook and now Meta, spoke about the creation of metaverse. This new concept is absolutely mind-numbing. Technology has evolved so much that a person in America could go with a person from India to the same sporting event, concert, etc. Every day, technology advances so much, and it would be disappointing if the legal fraternity doesn't innovate itself within time. In the end, I would like to conclude with the hope that we continue to innovate in the right direction with technology as our greatest strength. We are one of the strongest pillars of this democracy, and we, when I say we, I mean both bar and the bench. I don't want to leave out the bar at all. Must continue to live up to the expectations of the citizens of this great nation. I hope to meet you again, but before that, I must also mention about what Mr. Mishra pointed out in his presentation. He can be rest assured that not even one moment which in the interactions which we had between the Chief Justice's conference was without keeping in mind the efforts and the problems of the lawyers. Every time when we discussed, it is not only the litigants for whom all we work, but also the benefactors who are supporting the legal system. We always think about them. Now, it is a different matter that only the chairperson of the Bar Council of India was invited to the function. That function was not organized by the Supreme Court of India, but it was the government function to which the Supreme Court is also part of. So the invitation were extended, that privilege was of someone else. So excuse us for that. But being the chairperson of the Bar Council of India, I believe that you represent the entire legal fraternity of India. So your representation was so important in that function that, of course, it was indispensable as well. So I thank you for remaining present there and having shared your views on this occasion when the topic of the discussion was something different. Thank you so much and all the best to all of you. Please do wear mask and keep safe. Thank you.
Sir, thank you very much for this highly thought-provoking, stimulating and enlightening address. Now, leaders of the State Bar Association of Madhya Pradesh, Mr. Rameshwar Nikhara, Ms. Rashmi Ritu Jain, please come forward. Mr. Radhelal Gupta, if they are present here, Mr. Rameshwar Nikhara, Rashmi Ritu Jain, Mr. Radhelal Gupta, Mr. Rajesh Vyas, Mr. Vivek Singh, Mr. Sunil Gupta, Mr. Shailendra Verma, Mr. Ahadullah Usmani, Mr. Akhand Pratap Singh, Ms. Jay Hardia, Mr. N.K. Jain, please come here. Mr. Rameshwar Nikhara will present an image of Mahakal to Honorable Justice A.M. Khanwilkar. Nikhara ji. Ms. Rashmi Ritu Jain, be ready. Will to Honorable Justice J. Maheshwari. Rashmi ji. Mr. Radhelal Gupta to Honorable Justice Ravi Malimath. Mr. Rajesh Vyas to Honorable Justice S.C. Sharma. Rajesh Vyas ji. Mr. Vivek Singh to Mr. Justice Prakash Shrivastava. Mr. Sunil Gupta and Shailendra Verma to Honorable Justice Prashant Verma. Honorable Justice Prashant Mishra, I'm sorry. Mr. Ahadullah Usmani, Mr. Akhand Pratap Singh, Jay Hardia and N.K. Jain to Honorable Justice Rajendra Menon. Now finally I will request Mr. Pratap Mehta to propose the vote of thanks. You want a group photo? All right. Photographer, please. This is Madhya Pradesh exclusive. BCI members may also come for a group photo. All BCI members, please. Pratap Mehta ji, to propose the vote of thanks. Please come.
Sorry, Lordship, if you allow me, I want to speak in Hindi. लॉर्डशिप, आभार प्रदर्शन की बहुत लंबी लिस्ट है। इस प्रोग्राम में बहुत लोगों ने मुझे सहयोग प्रदान किया। माफ करना, भागदौड़ में मेरा थोड़ा थ्रोट इन्फेक्शन भी हो गया। सबसे पहले मैं आभार मानूंगा हमारे इंदौर के अभिभाषक साथियों का। इतने फंक्शन मैंने ऑर्गेनाइज किए, कई परेशानियां भी आई, कई से विवाद भी होते थे, लेकिन इस कार्यक्रम में सभी लोगों ने इतना सहयोग दिया कि मेरा जरा सा भी किसी से विवाद नहीं हुआ और किसी ने यह भी नहीं बोला कि मुझे बुके देना है या मुझे भाषण देना है। सभी ने दिल से सहयोग दिया। वैसे इंदौर के बारे में यह कहा जाता है कि हम कई जगह चर्चा होती है कि इंदौर के विकास का कि कोई बात हो या इंदौर का में कोई अच्छा कार्यक्रम आयोजित हो तो कई जगह विवाद होते हैं, लेकिन इंदौर एकमात्र ऐसी जगह है कि यहाँ के लोग इन कामों में सहयोग करते हैं। अब माननीय लॉर्डशिप, खानविलकर साहब, एम खानविलकर साहब, आभार प्रदर्शन मेरा थोड़ा लंबा हो जाएगा, लेकिन मैं अपने आप को रोक नहीं पा रहा हूँ क्योंकि आपके साथ कई कार्यक्रम में मैंने शिरकत की। उज्जैन की कोर्ट बिल्डिंग में जब मैं इनवाइट करने गया वहाँ पर कि आपको इनवाइट कोर्ट बिल्डिंग का उद्घाटन करना है, तो आप बोले केवल 4 रुपये लूंगा। मैंने कहा ठीक है लॉर्डशिप, आप आइए तो सही, 4 ही पहनना आप। फिर धीरे से मैंने बोला लॉर्डशिप, ये इतने वकील बैठे हैं, ये सब मुझे वोट भी देते हैं अगर ये हार नहीं पहनाएंगे तो सब मुझसे नाराज हो जाएंगे। लॉर्डशिप ने बोला ठीक है, कि सारे वकीलों ने हमारा स्वागत किया। मध्य प्रदेश के चीफ जस्टिस रहते हुए टेक्नोलॉजी के क्षेत्र में तो आपने काम किया ही। ये मीडिएशन प्रोग्राम, ट्रेनिंग प्रोग्राम है जो वकीलों के, वो आपने मध्य प्रदेश के कई जिलों में ऑर्गेनाइज किया और वकीलों को ट्रेनिंग भी दिलवाई। सबसे बड़ा जो काम आपने किया है लॉर्डशिप, आपको याद होगा, आपने हर जिले में एक रिड्रेसल कमेटी बनाई। तो जहाँ विवाद हो वकीलों के और दूसरे, वो विवाद अधिकांश उस रिड्रेसल कमेटी में सेटल हो जाए। और आज भी वो रिड्रेसल कमेटी चल रही है, आज भी वो काम कर रही है। उसके बाद हमारे मध्य प्रदेश की माटी के गौरव आदरणीय लॉर्डशिप जितेंद्र महेश्वरी जी, – 2002 में जब आप स्टेट बार काउंसिल के मेंबर थे, उस समय आपके साथ हमें काम करने का मौका मिला। कई ऐसे कंट्रोवर्शियल रिजोल्यूशन होते थे तो हम बोलते थे आदरणीय महेश्वरी साहब, ये आपका ही बस का काम है, ये रिजोल्यूशन का ड्राफ्ट आपको तैयार करना है। और उन्हें कई रिजोल्यूशन आपने ड्राफ्ट किए। सबसे बड़ी जो उपलब्धि आपकी है वो इंदौर कोर्ट बिल्डिंग की। कई बार आपने मीटिंग बुलाई, कई विवाद थे, कुछ अभिभाषक जाना चाहते थे, कोई नहीं जाना चाहते थे, लेकिन आपने सबको इकट्ठा करके और कोर्ट बिल्डिंग का उद्घाटन करवा दिया और आज कोर्ट बिल्डिंग का निर्माण कार्य चल रहा है। इसके बाद दूसरा एहसान हम लोगों पर है, स्टेट बार काउंसिल पर, कि स्टेट बार काउंसिल के बिल्डिंग के लिए जब इंदौर हाई कोर्ट के बिल्डिंग कमेटी के आप चेयरमैन थे, वह आपने जमीन हमको अलॉट करवाई और उस जमीन का पोजीशन भी आप मिल गया। कुछ कमजोरी हमारी रही कि हम वो बिल्डिंग का काम शुरू नहीं कर पाए, लेकिन आपको विश्वास दिलाते हैं कि वो आपने जिस वजह से हमको ये बिल्डिंग दिलाई और जमीन अलॉट की, तो हम उसको निश्चित इस बिल्डिंग का काम भी शुरू करेंगे। ऑलरेडी हमारे रवि मलिमथ साहब चीफ जस्टिस, ऑनरेबल चीफ जस्टिस, लोग कहते हैं कि बड़े स्ट्रिक्ट हैं। बड़ा सख्त एडमिनिस्ट्रेशन है, लेकिन दूसरी ओर लोग प्रशंसा भी करते हैं, तारीफ भी करते हैं कि मध्य प्रदेश में एक स्ट्रिक्ट एडमिनिस्ट्रेटर की आवश्यकता है। तो आज बहुत सारे सुधार आपके चीफ जस्टिस कार्यकाल में हुए और हो रहे हैं। आदरणीय सतीश शर्मा साहब, आपके साथ भी मुझे अब लंबा हो जाएगा, कई कार्यक्रमों में जाने का समय मिला। आप भी हमेशा बोलते थे मैं तो कार्यक्रम में नहीं आऊँगा, अरे मैंने कहा अभी लोक अदालत का है, आप पोर्टफोलियो जज है, आपको आना पड़ेगा, लेकिन आप खुशी से आए और कई सफल लोक अदालतें आपने करवाई। हमारे एडमिनिस्ट्रेटिव जज भी रहे इंदौर में, आदरणीय प्रकाश श्रीवास्तव साहब, आप भी एडमिनिस्ट्रेटिव जज रहे इंदौर में, और आप सब लोग न्यायिक क्षेत्र में ऊंचाइयों पर पहुंचे। राजेंद्र मेनन साहब, अब राजेंद्र मेनन साहब तो एक बार मैं दिल्ली में, आपका फेलिसिटेशन था, आप जब चीफ जस्टिस थे, मैं प्रोग्राम में थोड़ा लेट पहुंचा दिल्ली हाई कोर्ट के। आपकी सहृदयता देखिए कि मुझे बाहर से देखा और बोला आइए मेहता जी, खुद हो गए। तो ये भी इनकी हमारे पास, जैसे मनन मिश्रा जी ने बताया कि हमारी स्टैंडिंग कमेटी और एलईसी में भी है। आदरणीय प्रशांत मिश्रा साहब, अब वैसे तो मध्य प्रदेश के ये हैं, जबलपुर के, बाद में छत्तीसगढ़ में आप हाईकोर्ट जज हो गए, इसके बाद आंध्र प्रदेश चले गए। तो ये हमारे सभी जो न्यायिक क्षेत्र में जिन्होंने प्रतिष्ठा बनाई है, और उज्जैन का इंदौर का और मध्य प्रदेश का नाम का गौरव किया है, ये हमारे लिए बड़ी सराहनीय की बात है। हमारे इंदौर खंडपीठ के, ग्वालियर खंडपीठ, जबलपुर खंडपीठ के सभी न्यायाधीशगण यहाँ पर हैं। उन्होंने भी इस कार्यक्रम में आए, उनका भी मैं आभार मानता हूँ। इसके बाद रजिस्ट्री के लोगों ने बहुत काम किया यहाँ पर, उनका भी मैं आभार मानता हूँ। सबसे बड़ा आभार जो हमारे ये छात्र भविष्य, इस मध्य प्रदेश के देश के भविष्य है। मेरे पास 1000 छात्रों की लिस्ट थी कई जगह से। मैंने कहा भाई प्रोग्राम बहुत बड़ा हो जाएगा, इतनी व्यवस्था भी नहीं है, तो जिसने 100 नाम दिए थे उनको मैंने 25 किए। तो इन छात्रों का भी मैं बहुत बहुत आभारी हूँ। हमारे सभी अतिथिगण का, हमारे चेयरमैन मनन मिश्रा जी, कई लोग आपके पास बोलते हैं साहब कार्यक्रम, तो हमने प्रताप मेहता जी को फ्री हैंड दे दिया है, आप जैसा धंधा चाहे करें। और अभी तो 2-3 ऐसे ऑर्डर पास किए आपने कि दोनों खुश, दोनों पक्ष खुश। तो हमारे मालवी में लोग बोलते हैं कि लाड़ा भी खुश, लाड़ी भी खुश। और जो एक देश में नारा चलता है वो हमारे बार काउंसिल ऑफ इंडिया में भी शुरू हो गया, मनन है तो मुमकिन है। हमारे जिला न्यायालय के न्यायाधीश, अन्य न्यायिक अधिकारीगण भी यहाँ पर काफ़ी संख्या में है, उनका भी मैं बहुत बहुत आभार मानता हूँ कि उस कार्यक्रम में आए। हमारे प्रेस मीडिया ने भी बहुत पब्लिसिटी की इस कार्यक्रम की। डेली कोई न कोई हमारे सभी अतिथिगण का नाम अखबारों में देते थे। प्रेस मीडिया का भी मैं बहुत बहुत आभारी हूँ। और जो साथी हमारे वॉलंटियर्स हैं जिन्होंने सरस्वती वंदना की, और जो भी हमारे चीफ गेस्ट आए एयरपोर्ट पे, सबको आपने रिसीव किया, वॉलंटियर्स सब बराबर पहुँचे, उनका भी मैं आभार मानता हूँ। और सभी वॉलंटियर्स ने बहुत निष्ठा से निस्वार्थ काम किया, इनका मैं तहे हृदय से आभार मानता हूँ। मैं सभी अतिथिगण का फिर से एक बार आभार मानता हूँ। और उपस्थित सभी यहाँ पर हॉल में जो उपस्थित है सभी का बहुत बहुत आभार, धन्यवाद, जय हिंद।
प्रताप मेहता जी, आपके सार गर्भित और मार्मिक धन्यवाद प्रस्ताव के लिए आपका बहुत बहुत धन्यवाद। और आपका धन्यवाद बार काउंसिल ऑफ इंडिया की तरफ से, आपका आपके सभी साथियों का, मध्य प्रदेश के अधिवक्ता गण, खासतौर से इंदौर के हमारे नौजवान साथी के इतने भव्य सभागार में इतना भव्य आयोजन आपने करवाया, आपका बहुत बहुत धन्यवाद। नाउ प्लीज राइज फॉर द नेशनल एंथम। We are going to have a tea break of 10 minutes. So we are going to assemble again After 10 minutes for the second session.
सभी साथियों से अनुरोध है कि सिर्फ 10 मिनट का टी ब्रेक हम लोगों ने लिया है। जिस कार्यक्रम के लिए हम इकट्ठे हुए हैं, टेक्निकल सेशन हमारा अब शुरू होगा। हमारे सारे ऑनरेबल गेस्ट्स रहेंगे मंच पे, और जिस काम के लिए, जिनको सुनने के लिए हम यहाँ इकट्ठे हुए हैं, सारे हमारे माननीय वकीलों से, जो लॉ स्टूडेंट्स हैं, आप सबों से आग्रह है कि चाय लेने के बाद आप तुरंत अपने अपने स्थान पे आ जाएं।
Those who have already done with their tea may please come and take their seats. Our next session is going to begin in 10 minutes. Please come and take your seats. चलो हम तो अपनी तरफ से अनाउंस करेंगे ना. Please come inside the auditorium and occupy your seats, please. Please take your seats. We are going to begin in another 10 minutes. It's going to be a small session, the second session. And thereafter we will be breaking for lunch. Volunteers, please tell the members to come inside. जितने भी volunteers हैं वो participants को कहें अंदर आने के लिए. Please take your seats. Please come inside. All participants. I request the volunteers for today's program, please request everybody to come inside and occupy the seats. ये कार्यक्रम संक्षिप्त होगा, कुल 4 इसमें वक्ता हैं. There are only 4 speakers. And after conclusion of this second session, we are going to have the lunch program, and thereafter would be the third session. So please come inside so that we are able to start the program. Our speakers, our guests who are to speak today, they are waiting for you to come inside the hall and take your seats. हाँ, आपने किया है? अब उनको बुला लीजिए. हाँ, हाँ. So please come inside. Our guests have come for the second session. Volunteers, please ask the participants to come inside. The session is going to begin. We are going to start. Please come inside. वो तो कंडक्ट तो मैं कर लूँगा. You are requested to come inside and take your seats, please. The volunteers, please request everyone to come inside. Our Bar Council of India members, request to all members of Bar Council of India, please come and have your seats. पूछ लीजिए उनका सेकंड, उसमें प्रोग्राम नियम से पूछ लीजिए. मेरा ख्याल है उनका बोलने का नहीं है. हाँ विष्णु, so you will propose vote of thanks for this function. Okay, so we will start straight. No felicitation, no presentation.
Nothing.
So Suraj Sharma will offer welcome address, and Justice Rajendra Menon, Justice Ravi Malimath, and Justice Satish Chandra. That's all. And then vote of thanks. नहीं, उनको वहाँ रहने दीजिए. Because he सूरज शर्मा जी कहाँ हैं? बुलाइए.
First speaker will be Rajendra Menon.
No, Suraj Sharma will start.
Okay. High Court.
He will deliver welcome address. So, Mr. Suraj Sharma, President High Court Bar Association Indore. Suraj Sharma ji. Mr. Suraj Sharma.
He might be in coffee or tea.
No, that he is the first speaker.
He should be here.
And where is our Manan Mishra ji? So we are going to start the program. The second session on courts technology. I request Mr. Suraj Sharma, President High Court Bar Association, Indore, to deliver the welcome address. Mr. Suraj Sharma, please come. Please come.
जल्दी करने की तो आ जाए
आप शुरू कर दीजिए बस. गेस्ट बोलने वाले सब
ये लोग नहीं आए. मुख्य अतिथि माननीय न्यायमूर्ति सर्वोच्च न्यायालय श्री A.M. खानविलकर साहब, सम्मानीय अतिथि माननीय न्यायमूर्ति सर्वोच्च न्यायालय श्री J.K. महेश्वरी साहब, मध्य प्रदेश उच्च न्यायालय के मुख्य न्यायमूर्ति श्री रवि मलिमथ साहब, तेलंगाना उच्च न्यायालय के मुख्य न्यायमूर्ति श्री S.C. शर्मा साहब, कलकत्ता उच्च न्यायालय के मुख्य न्यायमूर्ति श्री प्रकाश श्रीवास्तव साहब, आंध्र प्रदेश उच्च न्यायालय के मुख्य न्यायमूर्ति श्री प्रशांत मिश्रा साहब, दिल्ली उच्च न्यायालय में पदस्थ रहे वर्तमान में आर्म्ड फोर्स ट्रिब्यूनल के चेयरमैन न्यायमूर्ति श्री राजेंद्र मेनन साहब, बार काउंसिल ऑफ इंडिया के अध्यक्ष सीनियर एडवोकेट श्री मनन कुमार मिश्रा जी एवं मध्य प्रदेश से पधारे सभी बार काउंसिल के सदस्यगण, मध्य प्रदेश शासन के महाधिवक्ता श्री प्रशांत सिंह जी, रजिस्ट्रार जनरल श्री कृष्णमूर्ति जी, प्रिंसिपल रजिस्ट्रार श्री मिश्रा जी, सदस्य बार काउंसिल ऑफ इंडिया कन्वेनर लॉ सेमिनार इंदौर के श्री प्रताप मेहता साहब, अन्य सभी बार काउंसिल ऑफ इंडिया के पदाधिकारी और सभागृह में उपस्थित सभी वरिष्ठ एवं युवा अभिभाषक साथी एवं प्रिंट मीडिया इलेक्ट्रॉनिक मीडिया के मेरे साथीगण, सभागृह में उपस्थित सभी माननीय सदस्यगण हमारे अतिथियों का स्वागत करना चाहते हैं, लेकिन समय के अभाव कारण यह संभव नहीं है। इसलिए मैं सभी की ओर से, हाई कोर्ट बार एसोसिएशन की ओर से, सभी सदस्यों की ओर से आप सभी का स्वागत करता हूं। सर्वप्रथम मैं अपनी स्वयं की व इंदौर उच्च न्यायालय संघ की ओर से बार काउंसिल ऑफ इंडिया और उनके सदस्यों का सहृदय से धन्यवाद करना चाहता हूं कि उन्होंने इतने भव्य आयोजन के लिए इंदौर को चुना और हमारा इंदौर शहर तो मां अहिल्याबाई होलकर के कालखंड से ही न्याय के लिए प्रसिद्ध है। आज मैं इस बात से भी बहुत ज्यादा प्रफुल्लित हूं कि मुझे भारत की न्याय व्यवस्था में के तटस्थ न्यायमूर्ति गणों के समक्ष कोर्ट रूम से बाहर खुले मंच पर बोलने का मौका मिला। कार्यक्रम के अनुसार अब हम अपने दूसरे सेशन में हैं, जो कि वर्तमान परिस्थितियों में प्रत्येक अभिभाषक के लिए बहुत ही गंभीर और महत्वपूर्ण विषय है, कोर्ट्स टेक्नोलॉजी। क्योंकि आज हम सभी एक इलेक्ट्रॉनिक ग्लोबल वर्ल्ड में रह रहे हैं और हर संस्था क्षेत्र आज टेक्नोलॉजी के माध्यम से अपना कार्य सुचारू, तीव्र एवं सरल करती जा रही है। एक कहावत है कि आवश्यकता ही आविष्कारों की जननी है। सभागृह में बैठे मेरे वरिष्ठ सदस्य मेरी इस बात से सहमत भी होंगे कि हम सभी ने यह विचार भी नहीं किया होगा कि न्याय भी घर बैठे हो सकता है। और जो परिस्थिति हमने कोरोना काल में देखी, उसको दृष्टिगत रखते हुए उस समय सिर्फ टेक्नोलॉजी के प्रयोग से ही हम न्यायदान करना संभव कर पाए और कई लाखों पक्षकारों को इससे लाभ और सुगम न्याय मिला है। और वर्तमान परिस्थितियों
और बीते 3 वर्ष हम सभी को सिखाकर गए हैं कि आने वाला समय सिर्फ टेक्नोलॉजी का युग होने वाला है। उपरोक्त विषय पर आज न्यायमूर्तिगण मुख्य वक्ताओं के द्वारा विस्तार से हम सभी को मार्गदर्शन किया जाएगा। अपितु मैं हाई कोर्ट बार के अध्यक्ष के नाते आप सभी का ध्यान इस बात पर आकर्षित करना चाहता हूं कि टेक्नोलॉजी के अभाव में अधिवक्ता बंधुओं को टेक्नोलॉजी के ज्ञान के अभाव में हो रही कठिनाइयों को दूर करना है भी हम सभी का दायित्व है, जिससे अधिवक्ता बंधु न्यायपालिका के साथ कदम से कदम मिलाकर न्यायदान में सक्रिय भूमिका निभा सकें। आज हमारी न्याय व्यवस्था दिन प्रतिदिन अच्छी और तीव्र गति से आगे बढ़ती जा रही है और आज हम टेक्नोलॉजी के माध्यम से न्यायदान करने में सफल रहे हैं। टेक्नोलॉजी से अभिभाषक बंधुओं को बहुत सीखने को मिला तथा इस नई टेक्नोलॉजी से न्यायदान में अपना पूर्ण योगदान देकर पीड़ित पक्षकार को न्याय दिलाने में पूर्णतः सफल रहे हैं तथा पीड़ित पक्षकारों को भी इस टेक्नोलॉजी से न्याय प्राप्त हुआ है। परंतु जिस तरह हम सभी किसी भी केस की तैयारी को परफेक्ट करते हैं ताकि सकारात्मक न्याय कर सकें, उसी तरह हमको हमारे अभिभाषकों को और कोर्ट रूम को परफेक्ट तरीके से टेक्नो फ्रेंडली करना होगा। हमारे द्वारा कुछ ऐसी समस्या भी इस दौर में महसूस की गई कि हमारे कई अभिभाषक सदस्य आज भी बेसिक सेल फोन का उपयोग करते हैं और टेक्नोलॉजी में इतने निपुण नहीं हैं। ऐसे हमारे सभी अभिभाषकों के लिए भी हम सभी को सोचना चाहिए और अभिभाषकों को टेक्नो फ्रेंडली करने के लिए निरंतर ट्रेनिंग प्रोग्राम करने का प्रयत्न करना चाहिए। जिला न्यायालय के अभिभाषक, जिला न्यायालय के स्टाफ रीडर्स के लिए भी ट्रेनिंग प्रोग्राम करना चाहिए। कुछ ऐसे सॉफ्टवेयर डेवलप करना चाहिए जिससे जिन केसों में सजा कितनी हो गई है यह जानकारी प्रतिदिन अपडेट होती रहे ताकि कोई भी पक्षकार न्याय से वंचित न रह सके। वर्तमान में सम्मन की तामीली को भी टेक्नोलॉजी से सर्व कराने के लिए हमको मंथन करना चाहिए ताकि न्याय में विलंब न हो। और इन सब में सबसे महत्वपूर्ण बात है कि टेक्नोलॉजी ऐसी न हो जिससे कि आप आम गरीब जनता के लिए न्याय पाना महंगा हो जाए और प्रयास यह होना चाहिए कि अंतिम व्यक्ति न्याय आसानी से प्राप्त कर सके, जो कि न्याय की मूलभूत अवधारणा है। और मध्य प्रदेश उच्च न्यायालय के मुख्य न्यायमूर्ति श्री मलिमथ साहब का भी यही संकल्प है कि मध्य प्रदेश को न्याय के क्षेत्र में सभी प्रकार से निपुण करते हुए प्रदेश में न्याय व्यवस्था को सरल, तीव्र, सुगम और सुनिश्चित कर विशेष स्थान प्राप्त करा सकें। और मैं इसी आशा से अपनी वाणी को विराम देता हूं कि जिस तरह समुद्र मंथन से अमृत प्राप्त हुआ था उसी प्रकार से सिन्नार के मंथन से हमें कुछ विशेष प्राप्त होगा। जय हिंद, जय भारत।
धन्यवाद सूरज शर्मा जी, बहुत सुंदर और सार्थक आपने बातें रखी। नाउ आई वुड रिक्वेस्ट ऑनरेबल जस्टिस राजेंद्र मेनन टू एड्रेस द गैदरिंग।
Good afternoon. Now, I have been entrusted with the task of addressing on one of the topics of the symposium pertaining to technology in the dispensation of justice. I propose to deal with the issue in a manner to highlight what are the problems that are being faced not by the mainstream judicial administrative process but the tribunals in the country. Because following me would be two Chief Justices who would address on this issue, and therefore I felt that the members of the bar who also appear in various tribunals should be aware of some of the problems in the implementation of technology that is being faced in these institutions. That apart, In the inaugural address, Justice Malimath had emphasized about access to justice and then the importance of technology into it. As he rightly said, until and unless you have access to justice, there is no use having the best technology. The person who is unable to access justice, what will he do with the technology being there in place? And therefore, I would like to touch upon a few aspects pertaining to this access to justice on the basis of what I call disparity in the dispensation of justice throughout the country. When I was in Delhi as Chief Justice of the High Court of Delhi, I found the best system available, the best facilities available for dispensation of justice to the litigants. The best facilities available to the lawyers. Everything was at its best. And when I thought of the period I had as the Chief Justice of Patna High Court or as an acting Chief Justice of Madhya Pradesh High Court, and when I thought of various district courts like district courts in Jhabua or in the remote places of Madhya Pradesh or Bihar, I found that even courtrooms, toilets, and there were courts in Bihar which did not even have boundary walls. And there I felt that is it not a system where there is great disparity in the dispensation of justice. I'm not talking about the high courts in particular. I'm talking about the last man in the queue, the man who goes for justice to a taluka court or a remote district court. What are the difficulties faced by him? That disparity in dispensation of justice is directly related to denying proper access of justice to a particular class of citizens, and therefore I feel that that issue also need to be addressed. And if you see the vision of our present Chief Justice, he speaks about having an infrastructural authority to address various issues. Yes, those are things which have to be addressed, and therefore, as far as access of justice is concerned, I feel that there should be an infrastructural facility. The system of access of justice should be equal throughout the country. For a person who goes to the Supreme Court, to a person who goes to a remote village in the states of Madhya Pradesh or Bihar or maybe UP, they should have the same facility which is available to a rural resident in the state of Kerala or Karnataka. Or, of course, Delhi, we cannot call it like that, but in the district courts in Delhi. Having said that, now I'll talk about the technology aspect of dispensation of justice in the administration of justice. In the high courts, in the district courts, we have the technology. All of you know how it is there, how it functions. I'll not go into that area except for saying that yes, technology is needed. To what extent it is needed is a issue which requires consideration, and therefore it has to be discussed in more detail involving all the stakeholders. But for the present, I'd like to emphasize upon the state of the tribunals and the technology being applied there. Why I am taking up the tribunals are, there are 22 tribunals working under the central government, and there are more than 40 to 50 tribunals which are functioning under various state governments. During the pandemic, most of the tribunal faced a peculiar problem that was, even if we wanted to hear cases virtually, we did not have digitalized record.
the advocates did not have digitalized record. If I wanted to hear a case in Jabalpur, sitting in Delhi, I did not have any technological facility to have the files in Delhi. The files had to be either scanned and sent by email to Delhi or physically transferred from Delhi, and then only virtual hearing could take place. There is no e-filing in the tribunals, except that individual tribunals have their own system of preparing the cause list and having a website, but the technology has not reached the tribunals to the extent it has been developed in the high courts and the subordinate courts in the districts of various states. This is one issue which I and we, few of the administrators of justice in these tribunals, have taken up with the government, and now we propose to take up the issue with Honorable the Judge in charge of computerization, Justice Chandra in the Supreme Court, and we are going to request the government and the Honorable Supreme Court to take over the e-committees and e-functioning of the tribunals also in the Supreme Court, so that the same facilities as are available to the mainstream courts are available to the tribunals also. I have to emphasize on this because I have seen the plight of the tribunals for the last 2 years. Why should a litigant who comes to the tribunal for justice be deprived of the same facility which would otherwise have been available to him had the tribunal not been there and he goes to the High Court? Service matter of an individual who comes to the High Court directly has a different technological facilities available which may not be available to a central government employee who approaches the Central Administrative Tribunal for dispensation of justice. So this is one area where the government should address the issue, and I would request the bar councils of the state and the bar councils of the Bar Council of India to be part of this venture of ours in taking up the issue with the government, because ultimately we have the members of the bar who practice in these tribunals also. I have about more than 1,800 members in the AFT Bar Association, and I am told the Central Administrative Tribunal has a strength of more than 3,000 members in the bar throughout the country. So when it comes to the aspect of technology in the dispensation of justice, I want that this also should be addressed by the authorities concerned. As far as the fact about implementation of technology in the dispensation of justice, as agreed by all, it has to be there. There is no dispute that technology is not required. But to what extent? What are the areas where technology should be there, and what are the areas where technology should not be used? In the matter of administration, maintenance of record, process of issuing notice and all, technology is applied in a different way, and it should be applicable 100% in those areas. But when it comes to hearing, recording of evidence, cross-examination of witnesses, examination of child witnesses, vulnerable witness, the question is to what extent the technology should be enforced. I personally feel that hearing, physical hearing in courts should not be completely done away with and we go to virtual hearing. Virtual hearing, in my view, should be restricted to
hearing of miscellaneous matters, admission, or maybe interim hearing applications. But when it comes to hearing of a case, finally, the physical presence of the lawyer and the judge should be there. When a lawyer reads a judgment before me and makes me go through each and every word in that judgment, the effect of it into my mind is different than when I hear him virtually in a video conferencing arguing a matter. There are various issues like this which should be taken care of when we implement technology. As Justice Khanwilkar said, artificial intelligence. Yes, artificial intelligence can do many things, but can it substitute my thinking, my brain, analyze fact in a manner in which we have to do it and take a decision? No. Artificial intelligence can be used for sending a notice to a litigant on the basis of the software developed for accepting the process fee. It can be used for sending intimation, but when it comes to application of mind and dispensation of justice by analyzing various things, it is only the human mind which can do it. It cannot be done mechanically. So there are various aspects. It's very easy to say that technology should be used for the dispensation of justice, but the second question is how, to what extent, and in what manner. That is what has to be discussed in detail and a decision taken. This symposium is a beginning to that, and let us, when we decide on various aspects of discussing how technology is to be implemented in the dispensation of justice, I feel we should discuss each and every aspect of technology, its effect on the system, its advantages, its disadvantages, and then decide what technology should be accepted, what should not be accepted, and then come to a conclusion. And here, not only the stakeholders like the members of the bench, the members of the bar, experts who represent the experts in the information technology and other aspects should be involved. Our difficulties should be told to them and then a decision taken. I propose to conclude my short address on the issue by only initiating a process of discussion which should not end by close of this symposium, but which should continue into various areas which I have tried to put before you. Thank you very much for having given me this opportunity. Jai Hind.
Sir, thank you very much for highlighting a very hard and harsh truth, disparity in dispensation of justice and disparity in availability of necessary infrastructure at various levels. We may be having very sound system as far as use of technology in Supreme Court, in High Court is concerned, but when you come to district courts, when you come to Mofussil courts, Tehsil, lawyers don't have even Android phones. This is a harsh truth. And we brought this fact to the notice of the Law Minister in a meeting held with the Parliamentary Committee on Legal Affairs. So these are very harsh and hard facts, and we will have to ensure availability of necessary facilities and training at all levels so that people are well versed in using this technology. Thank you very much, sir. Now I invite Honorable Justice Ravi Malimath, Honorable Chief Justice High Court, Madhya Pradesh, to share his views.
Dignitaries on the dais and off the dais, a very good afternoon to all. Justice Rajendra Menon's speech was indeed very enriching and there's enough food for thought, I think, for all of us to think about even after this symposium. Thank you, sir. The theme for the first session of this symposium is courts technology. Technology has permeated all sections of our lives. With each passing day and year, new technology is invented, which has the potential to further simplify our work. Some of this technology is truly promising and transformative. As I mentioned in the inaugural session, the former Honorable Chief Justices and judges of this court have ensured that the courts at Madhya Pradesh are front runners when it comes to successful adoption of technology. When it comes to courts adopting any new technology, there are a couple of items which we usually assess. The first is that of utility versus cost. Does this new technology have the potential to bring about a discernible change in the justice delivery system and justify its costs? Most of the technology is priced very steep, and hence the need to look at whatever it is, a positive change that is also sustainable. If there is no positive change, or if the change is not sustainable over a period of time, then the burden on the exchequer can be avoided. Technology ranges from tangible items such as computers and routers to intangible items such as software. Longevity of these items and any ancillary infrastructure that is required to be developed for these items are also factored in. Another important consideration is that of maintenance costs over the years. When I was heading the computer committee at the High Court of Karnataka, these questions on novel technology were usually being answered by the vendors of such technology. In order to get a wholesome picture on utility and feasibility of the new technology, I felt that it was necessary to include experts from the technology field who are more adept at assessing its true potential. As judges, we are all very well versed with the questions of law, but not experts at definitely assessing technology. Thus, technological experts from the Indian Institute of Science, Bangalore, and other such places were included on the panel. They would study the technology and provide fruitful insights which help the computer committee in ultimately reaching the decisions. In fact, the interactions that we would have with the manufacturers was so useful with the intervention of the expert from the Indian Institute of Science that it made our job so very easy. There are many things that we were unable to convey technically to the experts, which was done so beautifully by these the so-called experts that we had hired. So even hiring these experts to help the judges or the lawyers really goes a very long way. The second item which is important to consider while adopting any new technology is that of adaptability. This is essentially the ease of use and whether people will be able to successfully employ the new technology. The learning curve differs for each individual. Some people may take more time to adjust to it, and there is no problem with that. To evaluate the adaptability, we usually roll it out on a pilot basis to some people and then take their inputs. A good example set would consist of people who are well versed with technology as well as people who are not technologically adept. This would provide a well-rounded picture of workability. The input of the technological experts is valuable in this context as well. They can offer examples of successful or unsuccessful usage in other institutions. The experts are usually also in the know if a similar technology which is more user-friendly is expected to be launched into the future. Therefore, certain primary considerations, in my opinion, are utility, cost, and adaptability. A practical example that I would like to give based on my experience in Karnataka is that of a dictation device. These were newly introduced and they looked very promising for the purpose of cutting down the time it took for dictation. A judge could also dictate at any time and did not have to wait for assistance from the stenographer. The way the device worked was that the judge would have to read out the paragraphs, monitor what is being typed by the device, and make the necessary corrections. Over a period of time, the artificial intelligence software was supposed to attune to the pronunciation and voice of the judge, resulting in negligible mistakes in the typed documents. The minimum number of hours that were required for each training was around 150 to 200 hours. Because of the nature of the device and the hope that it would enable faster dictation and more disposals, we rolled it out on a pilot basis to a few judges. However, the feedback that we got turned out to be very disappointing. The judges would have to correct each and every word, and the situation did not improve even with time. They were spending a lot more time correcting a single iteration of the judgment than usual, and the general feedback that we received was that this device was not suitable for our use. These devices were also quite expensive at that point of time and had failed on all the three parameters of utility, cost, and adaptability. Ultimately, the committee decided to not procure the devices in bulk. Of course, there may be more advanced artificial intelligence now, and I'm sure that the dictation phones have vastly improved, which we need to reassess it once again. Technology and digitization of the courts has greatly benefited the advocates as well. As a fundamental level, for a good number of years, we had to wait for the cause list to be physically delivered to the house or the office. And the time at which you received the cause list would depend on the distance of your house or office from the court. Now, due to digitization, soft copies of the list are sent across much in advance, and this has reduced the burden on the advocates. With the digitization of cases and the availability of precedents online, it has become very easy for the advocates to search for precedents. Earlier, we had to read through each page of each journal and then write down the relevant portions on a piece of paper. The online resources now make it infinitely easier. What was undertaken in a few hours now takes just a few minutes. It goes without saying that those who prefer to read physical copies can always visit the library. The advocates must make effective use of all these resources. Adapting new technology might seem to be daunting at first, and it will definitely take time to get used to it. Nevertheless, the benefits of trying out new technology outweigh any disadvantages. Before I conclude, there is one thing which I wanted to share with all the advocates. Now, we spend crores and crores on technology. We give laptops, computers to the judges, we train the lawyers, we do as much as possible and try to transfer as much technology as possible to the users, only with hope of access to justice and to ensure that justice reaches the doorstep. But most of the time, the delivery takes time. And I really feel that the cost of an adjournment is very heavy on the institution. I really don't see reasons why an advocate should seek an adjournment. Now, you may not like what I am saying, but the fact is, as we all know, and as even the chairman of your bar council said, we are two sides of the same coin. If there's any genuine reason, certainly no judge will object to an adjournment. But if an adjournment is being taken just for the asking, it's not going to help. How much ever we may advance technologically, we are not going to progress unless there is a cooperation from the bar. So notwithstanding the technology, notwithstanding all the inputs that we put in, my humble request to each one of the bar members is, please avoid taking unnecessary adjournment in the cases. It's ultimately we are doing all this to ensure that justice is delivered in a shorter period of time, that justice is quick and real. Now, if having all this technology and we continue to adjourn the cases, it just doesn't answer the equation. So I request you to have a change of mind on that and to assist us in the quicker disposal of the cases. Thank you.
Sir, thank you very much for touching the most relevant aspect, ease of use of technology and cost and maintenance cost of the new technology. Very, very relevant. Now, I would request Honorable Justice Satish Chandra Sharma, Chief Justice High Court of Telangana, to share his views.
Honorable dignitaries on the dais, off the dais, ladies and gentlemen. First of all, at the outset, I thank the organizers for inviting me to attend Symposium on Courts Technology and Access to Justice, Changing Perspectives. Access to justice in a country is placed on the high pedestal of fundamental rights. It's an inbuilt content of Article 14, which guarantees equality before law and equal protection of laws. The state must provide effective adjudicatory mechanism which should be reasonably accessible, and the process of adjudication must be speedy and affordable to the litigants. The citizens shall be able to seek and obtain remedy of their grievances through a formal or informal institutions. If they have fear in this system or do not access it or cannot afford it in terms of finance or do not have knowledge or information about their rights, it means there is no access to justice. Access to justice involves legal protection, legal awareness, legal aid and counsel, adjudication and enforcement. Access to justice is essential in resolving personal political disputes for sustenance of peace and an alternative to the violence or anarchy. The Supreme Court, as early as in 1956, in BD Supply Company versus Union of India, reported in AIR 1956 SC 479, while interpreting Article 14, held that a constitution is not made only for the elite, but it is also for the butcher, the baker, and the candlestick maker. With the advent of computers and information technology, access to information has become unimaginably easier and faster. Computerization and information technology are providing solutions to many problems in a day-to-day life. One of the most important challenge we are called upon to take up today is rendering speedy and effective and substantive justice. In the year 2004, itself, the E-Committee has been constituted to formulate a national policy on computerization of Indian judiciary and to advise technological communication and management-related changes. Even before the pandemic, the E-Committee had called on the courts in the country to use technology to improve the experience of litigants, especially people who do not have attorneys. After the pandemic, all the courts, one by one, quickly shifted from requiring people to submit documents and appear in person before judges to widespread use of electronic filing systems, virtual hearing platforms, and other tools. The outbreak of COVID-19 in 2020 forced many organizations to shift online operations in short time. The courts have started online hearing of cases to administer justice. Digital transformation in criminal courts and deployment of new technology in the civil legal system also took place at rapid pace. The adoption of digital tools in the civil courts has significant implications. Technology, with its many forms and tools, works as an enabler for the judiciary to perform the complex procedures with ease and consistent accuracy. Tangible and intangible forms of technology are transforming the way the judicial administration is carried out on daily basis. On the tangible side, ICT infrastructure is helping the judiciary in functioning of virtual courts, video recording of evidence and court proceedings, conducting of virtual training programs. On the tangible side, it is helping in conducting of paperless courts, e-courts, issuance of online CD, digitization of case record, orders portal, implementation of artificial intelligence. Digitization will enable any litigant or lawyer to file a case from anywhere at any time without having to go through multiple windows in the premises of a specific court. It will be put in place an intelligent system that enables data-based decision-making for the judges and registries while scheduling or prioritizing cases and allows for greater predictability and optimization of the capacity of judges and lawyers. For the purpose of adopting new technologies and ideas, it is necessary to have a legal database, digital library in the judiciary by collecting all digital related objects to judiciary. Blockchain technology for issuance of certified copies of orders and documents to avoid forgery of documents is very useful. So also the appellate courts will have access to lower court data. The portal link of interoperable criminal justice system will enable the judges to see the information of the accused as to how many times he was lodged in jail and other cases pending against him. With the introduction of computerization in courts, every case filed here can easily be monitored right from the stage of filing and all through till it is disposed of. Now a daily, weekly and monthly statement of the status of court with respect of filing, disposal and pendency of different category of cases can be generated, which would enable the presiding officer of that particular court to manage the files, and it would be very handy for the superior courts to constantly monitor and supervise the local courts. All the courts in the state will have a linkage with the High Court and with the Apex Court. When every case is amenable to close scrutiny, nobody, the presiding officer, the practicing lawyer, and the litigants can be misled. Coming to Madhya Pradesh, because basically I am from Madhya Pradesh, the E-Committee literally started working from 2013 Madhya Pradesh, though it was started in 2004 at the center. After Honorable Justice Khanwilkar joined the E-Committee, I was fortunate enough to be a member of the MP E-Committee. Trust me and believe me, we are on the top in the country so far as Madhya Pradesh is concerned. When I went to Karnataka, there was no system of auto-dating. The cases were not having dates. 2 officers were deputed to the state of Madhya Pradesh. They were trained and they were explained how auto-dating takes place, meaning thereby every case should have a date. A litigant wants to know when his case is listed, which is not there in large number of high courts. When I went to Telangana, again people were deputed to go to Madhya Pradesh and to learn that software. So basic softwares we are borrowing from Madhya Pradesh, whether it's, I'm sorry Ravi, whether it's Karnataka or whether it's Telangana. The Madhya Pradesh High Court is having live streaming of court proceedings which we don't have in most of the courts. Computerization listing policy of the High Court for the benefit of duty holders and stakeholders, of course, was initiated by Honorable Justice Khanwilkar when he was there in the state of Madhya Pradesh. Scanning and digitization of record is taking place with great pace in the High Court as well as in District Court. The integration of land records has taken place in the state of Madhya Pradesh. In some of the states, it's again taking place. Virtual hearing of cases and paperless courts, they are functional in Delhi High Court, but still in Madhya Pradesh, we have started paperless court at Gwalior as well as Jabalpur. We are having e-court services, Lok Seva Kendra, in the state as well as in other states also. Customized web conferencing solutions for the High Court and District Court is in place. Obtaining a certified copy was a Herculean task earlier. We have of course, again, I'll come back to Madhya Pradesh. We have developed a software and certified copy can now even be obtained online. Because of digitization, every order is uploaded on the website. The actual file moves to the copying section. With one click, the man sitting in the copying section gives a certified copy. In Telangana, I was requested to depute 20 people to the copying section, and when I requested them to tell me the reason, they said 16,000 applications are pending. Because we don't have this updating system of all orders, of all record. So most of the best practices we are borrowing from Madhya Pradesh. In Delhi High Court, 22 judges were manning the motor vehicle challan system. But now there is online payment of challan system, online disposal of cases, and only one judge is now looking after the work of 22 judges in the entire Delhi. So this is how technology helps us. We have to borrow best practices from the high courts which are having best softwares and best technology. I'm once again thankful to Honorable Justice Khanwilkar, who took some time for us. And he was the person who introduced me to this computer committee. Under his guidance, we have developed a lot of softwares. And in the Supreme Court E-Committee, we have drafted large number of rules regarding video conferencing, e-filing. And you have seen the result during pandemic. Only the courts were working throughout the country, whereas large number of departments were closed. We never stopped. We are working for the litigants. We were doing the job of dispensing the justice. And therefore, in my humble opinion, this technology is very important for the judiciary. Thank you and Jai Hind.
Thank you very much, sir. Effective mechanism for securing justice. This is what the government should be grappling for. And bar and bench is always there to do their optimum. Thank you so much, sir. Now I request Mr. Vishnuvardhan Reddy to propose the vote of thanks.
Sun never rises without the use of the technological devices, cell phone, computers and internet by one and all of the people of this country. And we always use the technology, which is an important and integral part of everybody's life in the present society. Judiciary is not an exception to that. Sir, it is not we use technology, but we live technology. That is what the order of the day of today. So everybody is inevitably has to accustom, habituate and use the technological devices for movement of their lives of every day. Sir, it has been a great honor to be a part of this wonderful event, particularly the first session of a symposium, Courts Technology. Sir, all three great, efficient and wonderful speakers, Honorable Justice Sri Rajendra Menon sir, Chairperson Armed Forces Tribunal, and also Honorable Justice, Chief Justice Sri Ravi Malimath, Chief Justice High Court of Madhya Pradesh, and also Honorable Chief Justice Telangana, Justice Satish Chandra Sharma ji, and all three efficient and very energetic speeches they have given. And not only that, they gave the wonderful advices, and not only to the lawyers but also to the government. And all the honorable judges have emphasized the need, use, adaptability of these technological instruments and devices in the everyday's life of human beings. Sir, coming to His Lordship's Justice Sri Rajendra Menon sir, we thank you very much for giving great, valuable and thoughtful, provoking speech and suggestions. You have emphasized the need of technology for lawyers. You also further said that remote places of Bihar, MP and other states, even the courts have not having a compound walls and even the basic facilities.
including the technological devices. Your Lordship has suggested to make available all the important technological devices to the legal fraternity, particularly the advocates. Without providing these technological devices, the dispensation of justice to the people who are needy for justice is a Herculean task and very difficult. And your Lordship further said that, my lords, there were 22 tribunals in the central government and 42 tribunals approximately in the state government. And all the tribunals are not having the minimum technological facilities, because Article 21 is an important basic right of the citizen of this country, and it is the duty of the governments to provide, sir. Definitely, your suggestions will be taken into consideration by the government, and Bar Council of India Chairman Manan Kumar Mishra, sir, also on behalf of 20 lakh lawyers of this country will bring to the notice of the central government without fail, sir, as a statutory body of the highest apex body of this country. And the Honorable, the Chief Justice of Madhya Pradesh, Justice Ravi, sir, Ravi Malimath, sir, and your Lordship said the new technology will bring discernible changes to the access of justice to one and all, and the technological devices to be made available to all, and then only justice can be dispensed. And your Lordship further said technological experts, it is like a Mumbai IITians and other IITians needs to be involved more and more. And your Lordship further said utility, cost, adaptability are more important aspects in technological issues. So they needs to be addressed and resolved by the government, by the state and central government. And also your Lordship further said that technology and its use is a lot of benefits to the lawyers and the litigants. Your Lordship further said it reduces the burden on the lawyers and judges for use of technology, and because this is a 21st century where the burden is reduced, for the same thing lawyers should not seek adjournments for the sake of adjournment. It's a wonderful suggestion, sir. Definitely this symposium, definitely, sir, all the attendants of this symposium and the Bar Council of India, Bar Council of Madhya Pradesh, definitely, sir, will bring to the notice of your Lordship views to the central government as well as state government. And coming to the very efficient the speech by the today's symposium, Honorable Justice Sri Satish Chandra Sharma ji, sir, because he has advised access to justice is a fundamental right under Article 21. It includes all varieties and all aspects in providing the justice, including the digital technology. Definitely, sir, this is the country's India, it is a country of the poor people. Definitely, mere the article having a 21, without there being that help to the people, particularly to the citizens, is of no use. So therefore, all sections of the people should be taken into consideration. For strict implementation of Article 21, all the devices should be made available to the litigant public and the lawyers and the honorable judges. And sir, your Lordship further said, advent of technology is a great development to the judiciary. So definitely, sir, your Lordship's views are very valuable. And for this first session, and more preferably, Honorable Justice Sri G.K. Maheshwari, sir, and also Honorable Justice, Chief Justice of Andhra High Court, Sri Justice Prashant Mishra, sir, and the other Honorable Judges of the Madhya Pradesh High Court, and the Honorable Judges of this Indore bench, Gwalior bench, and my Honorable Chairman Bar Council of India, Sri Manan Kumar Mishra ji, esteemed Bar Council of India members, and the Chairman Bar Council of Madhya Pradesh, Vice Chairman BCA member Mehta ji, esteemed members of the Bar Council of Madhya Pradesh, High Court advocates, High Court President, the Executive Committee, young advocate brother and sisters, your presence made more beauty to this session, and this the address by all these eminent speakers, honorable the judges, will definitely benefit to all the participants of today's session, sir. Thank you very much, sir, for participating, for giving your valuable time and sparing all the way coming from the Honorable Justice, sir, Sri from Telangana, and also, of course, Madhya Pradesh, Jabalpur is also very long, and Armut Tribunal from Delhi. All you spared the time, though it is a motherland for you, for some of the honorable judges, you spend the time for Bar Council of India. Thank you very much, sir, for sparing your valuable time. Jai Hind.
Thank you, Vishnu. And now we are going to have a lunch break for half an hour. Session 2 will start at 2:45 p.m. So I request all the volunteers to lead the participants to the basement where arrangement has been made for the lunch. So after half an hour, we are meeting again for session 2. Thank you so much. कहाँ है मिश्रा जी?
All with guest card.
I request Mr. Manan Kumar Mishra to escort the honorable guest on the dais.
वो भी आ गए, प्रकाश श्रीवास्तव सब
And दोनों मिश्रा जी दोनों हैं. Mr. Manan Kumar Mishra, Chairman Bar Council, Mr. S. Prabhakaran, Mr. Mehta and Mr. Vishnu Vardhan Reddy, please escort the honorable guest on the dais. Honorable Justice Prashant Mishra, Chief Justice High Court of Andhra Pradesh, and Honorable Justice Prakash Shrivastava, Chief Justice Calcutta High Court, have joined us on the dais. We are going to begin the program. And friends, today So friends, today is Mother's Day. A very hearty greetings to all of you on Mother's Day. हम मातृ शक्ति को प्रणाम करते हैं, नमन करते हैं. So we begin our session. Mr. Sisir Malhotra, Chairman Bar Council of UP, please come. Mr. Malhotra will address the gathering. Please come.
I have been told to conclude in 5 minutes. For brevity, kindly let me introduce to the dais, and I directly come to my address. Already much has been said by the esteemed speakers, and I am no match to their experience and wisdom. However, being a professor at law and also the chairman of Bar Council of UP, whatever I have to offer, I would speak on the fundamental side, on the aspect of law. Let us not forget the theory of Darwin. That is the survival of the fittest. It is not the strongest and it is not the bravest who wins the race of survival. It is ultimately the species, it is ultimately that mechanism which adapts itself to the changing times, to the demands of the time and the vicissitudes of times. And there is no second thought on this aspect. Let me take you a few centuries back, that India lost in the race of capitalism because we did not catch up with the Industrial Revolution. And this technological event which our era is witnessing, it is the second financial revolution which is known as digital revolution. We all know that India has coped up very well, and it is the Indians who are ruling the Silicon Valley. But alas, and with due respect, I would let this August gathering ponder for a second that are we not late in adopting the technology? Is the legal field not late in adopting the legal technology? We have this question posed before us, highlighted before us, very specifically to the COVID disease which has overtaken the humanity. And kudos to the Indian judiciary, to the Indian judicial system, to both the bar and the bench, who have coped with it very well and had delivered and come out with flying colors. But the question remains. And let me remind you one thing more, that which is the biggest fear of humanity? The biggest fear which anybody can have is the fear of the unknown. Let us introspect that is it not fear of the unknown in adopting the technology? Because what technology has to offer, we cannot let it go. The speed, the swift nature of retrieval, the certainty in law, it is less spacious, and etc., etc. So why are we having second thoughts in adopting the technology in whatever it has to offer? But as students of science, we all know that first comes the hypothesis. Now I come to the antithesis. We have the lack of infrastructure in our country. As rightly pointed out, the Mufassil towns, the tehsils, the lesser developed districts, they do not have infrastructure. We are not here to criticize any part of the government, but it is a known truth that judicial system is a foster child of the government. We are not given the budget we need, our courts are never filled up, etc., etc. So this lack of infrastructure is something which we have to seriously think upon, because it is not to go in a day or two. Then there is an absence of human touch. We are very fortunate to have the best legal minds in India here, and we all know that in the absence of a one-to-one facing the judicial, the bar and the bench, we are not able to put up our points very well. Then we are not able to comprehend or to acknowledge as to what is missing or what the judge can give. He can give us some inklings, some hints as to where he is not satisfied with our case. This is the loss of human touch in use of technology. Then there is laxity in discipline also. There have been many cases where we have been seeing that the lawyers, they come up very not in their uniform, and then there is that very infamous, which I am not going to go into detail, the infamous cuddling case, as you might all be knowing. I won't go into the details of that, but it is certainly a vice of having the technology beyond a certain limit. Now the question, now the thesis, what comes from the hypothesis and antithesis. The takeaway message which I have to offer to this August gathering is this: the system of adopting the technology without any limits. We should remember, First of all, let us see what is the definition of technology. Technology is actually applied form of science. And I very well know that everybody must have written an essay in our childhood that science is a good servant but a bad master. Similar thing applies to the technology as well. If we are able to control it, let us not forget the lessons of Roscoe Pound, of balancing the interest. Let us not forget the sociological dichotomy which is existing in our nation, that is India and Bharat. India is developing without leaps and bounds, but Bharat is lagging behind. And I think this is what we have to keep in mind. We have to balance the interest of adopting the technology with certain limits. Limits have to be formulated. And this, we should not forget. The last thing which I have to say is this, that the essential function should not be delegated, as we all know in the Greek maxim, that delegatus non potest delegate. So, what I ultimately have to say is this, that technology should be adopted if we have to run. Time constraint. Yeah, I'm concluding with these words. So what is the takeaway message which I have to offer here is this, that technology should be adopted without any ambition, but we should not lose the human touch and also see the balance of interest between the various conflicting interests and the stakeholders. That's it. Thank you.
Thank you, Mr. Mehrotra, for touching very crucial practical aspects of the issue. Thank you very much. Now, I request Honorable Justice Prashant Mishra, Chief Justice High Court of Andhra Pradesh, to share his views with you.
J.K. Maheshwari, Judge Supreme Court of India, Justice Ravi Malimath, Chief Justice High Court of Madhya Pradesh, my brother on the dais, Justice Prakash Shrivastava, Chief Justice Calcutta High Court, Brother Mehta and Brother Vijay Prakash Sharma, Mr. Manan Mishra, Apurv Sharma, and all the dignitaries of the Bar Council of India and State Bar Council of Indore, my brother judges from Madhya Pradesh High Court, all the benches, my dear advocates of the Indore Bar Association, ladies and gentlemen, it's feeling like coming back to home when I am in Indore, part of Madhya Pradesh, my erstwhile state, and meeting my old friends. There is no pleasure greater than this occasion in life. Subsequent events sometimes precipitates the need of the access to justice, and Mr. Pratap Mehta has switched off the air conditioner in the second half, asking us to feel how if there is a grievance, but there is no access to grievance redressal, how do you feel? Anyway, let us begin. And he has also indicated while requesting my previous speaker to put it short. He already indicated that your submission should be brief because it is the need of the hour. We go back to the maxim ubi jus ibi remedium. Where there is a wrong, there has to be a forum for redressal. The word access itself signifies a right to move towards remedy. The principle be traced back to principle of Roman law, that ubi jus ibi remedium. In Dhannalal's case, Honorable Supreme Court has held that if a man has a right, this means to vindicate and maintain such a right. There is also a remedy if he is injured in the enjoyment of the aforesaid right, and that will be indeed an absurd thing to imagine a right without a remedy. for the want of right and the want of a remedy are reciprocal. Equality before a law is also one of the facets of access to justice. The principle of supremacy of law places checks and balances over the government functions on making and administering law. The principle of equality before the law ensures that procedure by which laws are administered are just and fair. It ensures that there must be equality before the law and equal protection of the laws. It prohibits discrimination on the basis of sex, religion, race, etc. Access to justice in layman terms means approaching the courts and judicial forums with minimum obstacles and through maximum ways for seeking relief against any human right abuses. In a democracy, the right of access to justice is visualized as a sine qua non. Access to justice has encountered various phases of important transformation over the years because initially it was considered symbolic to mere formal right of an aggrieved person to litigate or defend their interests before the court of law. However, this understanding of access to justice progressed because it no longer only refers to the basic right of litigation, but it also includes the opportunity to receive redressal against violation of human rights in a just, fair and speedy manner. There has been a shift where access to justice is not merely a natural right, but has also become a right to effective access to justice. This took place due to emergence of welfare and egalitarian state in 90s, where effective access to justice is seen as the natural right which proclaims as well as ensures legal rights for everyone in India. Under the current modern egalitarian legal system, the right to access justice has two projections. One is that it must be accessible to all, and two, it must result in giving reliefs that are individually as well as socially just. Article 32 and 226 are the two provisions in the Constitution which provides for redressal of grievances, whether it be violation of fundamental right or violation of fundamental as well as statutory right. The preamble of the Constitution also ensures to every people justice, social and economic and political, which means provide justice or access of justice to citizens of India in different aspects of social, political and economic. Martin Luther King had once said that injustice anywhere is a threat to justice everywhere. Access to justice is a basic right that guarantees protection of law to all. It is integral to rule of law. No one is above the law, nor even the state. Everyone should be able to seek protection of laws and legal redress for their grievance. The evolution and emergence of PIL jurisdiction is another facet of providing access to justice to those ignorant class of society, illiterate and poor marginalized class of society who don't even know that what is wrong for them and that what is happening to them, their pitiable condition, is in fact a constitutional violation, and they don't even know that there is a forum to approach for redressal of their grievance, and that is how we have evolved. Our great judicial system and our democracy has evolved this PIL jurisdiction to provide succor to the pitiable mass who are suffering because of ignorance. In Anita Kushwaha, 2016, Volume 8, SCC 509, Honorable Supreme Court has held that access to justice is a facet of right guaranteed under Article 14 and 21 of the Constitution of India. The four facets that constitute the essence of access to justice is that the state must provide an effective adjudicatory mechanism. Number two, the mechanism so provided must be reasonably accessible in terms of distance. Number three, the process of adjudication must be speedy. And number 4, the litigants' access to adjudicatory process must be affordable. The adjudicatory mechanism to mean that to ensure access to courts and thereby access to justice, a fundamental requirement would be to have mechanisms that enforce the same. These could be courts, tribunals, commissions, authorities, where a citizen may go to report a dispute or problem which may have been caused by another individual or the state or any of its instrumentality. This mechanism must prove to be effective, fair, reasonable and speedy. It should not ensure justice and recognize the principles of natural justice. Courts and other forums that resolve disputes should be reasonably accessible to all. This means that in rural areas, there should be provisions of mechanisms that solve disputes. Resolving disputes depends a lot on the ability of the litigant to travel to the court or the competent authority. Getting access to courts and to justice will be nothing but a mere illusion and a mere waste if the process isn't speedy. If the process is time-consuming, laborious and frustrating, it will dissuade more and more people to step back from the process. In Sila Barse, the Honorable Supreme Court explicitly held out and emphasized on the importance of having speedy trial that will act as a facet to the right of life. Access to justice would have value and significance and utility only if the delivery system is speedy. One of the biggest reasons as to why people prefer not approaching the courts when they have a legal dispute is because of the high costs that are quoted for legal services. This I'm referring to specifically to all the fraternity, all the legal fraternity also. The legal services should be more accessible and affordable to all. If this is not done, then the system will be nothing but a mere illusion. Legal aid to the needy has been recognized as one of the facets of access to justice. Lawyers should be careful that the litigant who approaches them should be provided affordable access to justice. There are a series of cases, n number of cases, wherein the Supreme Court has highlighted the various facets of access to justice. In Hoscott's case, that is M.H. Hoscott was State of Maharashtra, Justice Krishna Iyer has declared that if a prisoner sentenced to imprisonment is virtually unable to exercise his constitutional and statutory right of appeal, inclusive of special leave to appeal, for want of legal assistance, there is implicit in the court under Article 142, read with Article 21 and 39A of the Constitution, power to assign counsel for such imprisoned individual for doing complete justice. The term access to justice and the need to have access to the courts were felt more particularly during the COVID period, where people were running helter-skelter because of closure of the courts. And as Honorable Justice Maheshwari put it, probably Andhra Pradesh was the one of the first pioneer state high courts who started conducting e-courts by Zoom meeting and etc. In the first part of the seminar, we had focused on the court technology, and providing court hearing through virtual mode is a part of court technology, but there's an element of access to justice also in that court technology issue. And that is why this theme of the seminar has been chosen, and correctly so, by assimilating the court technology with access to justice and in the changing perspectives. In this very connection, when I was as executive chairman of SLSA Chhattisgarh, when I was there, and the entire legal aid movement was standstill in the first phase of COVID, And when we started virtual hearing, I thought that if virtual hearing can be done, can be conducted, and in contested matters, relief can be provided, why not conduct Lok Adalats also through virtual mode? And it gave rise to conduct of the first state level Lok Adalat conducted by me in the state of Chhattisgarh on 11th of July 2020. And that is how in the need of the hour, the evolution to the principle of access to justice should be redefined and expanded. My speech goes up to another 7-8 pages, but Mr. Mehta has already indicated. And I would confine here. There are various facets. Access to justice is such a vast subject that the entire law focuses on access to justice. Whichever new law is made, a new wrong is identified by the legislature by enacting a new enactment, a remedy is to be provided. And when remedy is not provided, then this provision under Article 26 is always open, and our constitution is an ever-evolving organic constitution which always provides access to justice to all, and through PIL, anybody can approach. When the cause is common, the litigant, the sufferer is not known, is an unidentified mass. I would thank the organizer, the Bar Council of India, and the State Bar Council of Madhya Pradesh, who have given me this opportunity to come back to home, meet my own people, and address the gathering. I am really very thankful to all of them. Thank you so much.
Sir, thank you very much. It has been a very enlightening address, and howsoever brief it may have been, your Lordship have highlighted the factors necessary for ensuring access to justice to the last man. Thank you very much, sir. And now I request Honorable Justice Prakash Shrivastava, Chief Justice, Calcutta High Court, to share his views with us.
A very good afternoon to all of you. We are all running short of time, so I'll cut short the preliminaries. I follow the path of Honorable Justice Khanwilkar. Article 141 also says so. So, dignitaries on the dais and off the dais. I'm very happy, delighted to be a part of this function, because this gave me an opportunity to come to Indore, where I have worked as a judge for 12 years, exact 12 years. I have learned a lot here. I don't know whether the lawyers have learned anything or not, but for me, I know it was a smooth working and a wonderful tenure of 12 years in this place. Now, coming back to the topic of this session, that is access to justice, changing perspective. That means where we were, what was the position earlier, where we are, where have we reached, and what is the future path. And when we think of access to justice, this reminds us, from the childhood we have read the system which was introduced by Jahangir, the fourth emperor of the Mughal Empire. He had installed a golden chain of justice. From Shahaburj, that was his palace, to river Yamuna, he had erected a big pole there, and there was a chain running from palace to the pole, and 60 bells were put there. And whosoever in his area used to feel that the injustice has been done, he could go there, ring the bell, and instantly there was a remedy available. His grievance used to be heard and solved. Now let us see our system, whether we have the same kind of system. Circumstances have changed. Population has grown many times. Litigation has increased many folds. Complexity of litigation has gone up. The king has been replaced by, because there is separation of power, is replaced by the judges. The oral prayer of justice, that is replaced by the written prayer, writ petitions. Now that chain, golden chain, having 60 bells. Now we have registry officers, we can compare it with them. There is a registrar general. Now, even at night, if you feel that yes, there is a matter which cannot wait till the regular court time, assembling of the court, you can go to the registrar, make a request. If it is found to be urgent, then even at midnight, the matters are heard. So we have the system. We have the access of justice, at least theoretically. Practically, yes, this kind of remedy is not available to everybody. It's not possible also. If we go back to the ancient India, the kings used to follow Rajdharma. And Rajdharma was that yes, king has a duty to deliver justice. And there was no discrimination between rich and poor. We have the examples when the kings used to go out at night in disguise amongst the people, and they used to see whether the crime is being done, whether the praja is living peacefully. And if they detect any injustice, they used to immediately do justice. So that was the system. We all know Chanakya Niti, which says that the king is God. We all know Kautilya's Arthashastra, which says that the king had the responsibility to have a system of delivery of justice. So that is the stage from where we started, if we think of access of justice. Let's move forward. Pre-independence period, there were issues of access of justice. When Quit India movement took place, 1942-43, there was Defense of India Act. Those who were participating, they were arrested, detained. Now, there was no access to lawyers. There was no access to courts, because that is what the Defense of India Act provides. Matter went to the court. We have the famous judgment of P.K. Tare versus Emperor, AIR 1943 Nagpur. The court says no. The Defense of India Act does not come in the way of access to justice. They have a right to go to the court. When India became independent, the Constituent Assembly deliberated upon the issue of access to justice. Detailed discussions took place. And our Constitution came. Article 32 is there, which says If any fundamental right is violated, you can directly go to the Supreme Court. 32 itself is a part of fundamental right. Article 226 is there. Now the question arises, when all this is there, then what's the issue of access of justice? There are problems. India is a very large country, geographically very large. There is problem of approaching the court. A man living in the remote village, he has difficulty in coming to the court. There are problems of costs. The lawyers, I won't say lawyers' fees because all the lawyers are sitting here. But there is a cost involved in coming to the court. Direct costs, indirect costs. Direct cost is litigation cost, indirect cost is cost of traveling, cost of leaving the work. Suppose an agriculturist is there, harvesting season is there, though injustice is done, he can't leave his work and go. Social factors are there. We have seen the cases of molestation, rape, because of the community, because of the stigma, they don't go to the court. Economic factors, social factors, all these factors, they come in the way of access to justice. But we all know, when there is a problem, there is always a solution. Because problem, they force us to find the solution. So for these poor, downtrodden, those who are ignorant of their rights, situated far off, for them, then concept of public interest litigation, that has evolved. Bandhua Mukti Morcha judgment we all know. When the bonded laborers, they were rehabilitated, they were given the relief. NGOs, social workers, public spirited persons, they all come forward with the PILs and courts entertain them. Rules of locus standi has been relaxed in public interest matters. For what? For access to justice. Letter petitions are entertained. You write a letter, if there is an issue involved, it is entertained as a petition. And leave aside letter petitions. Courts sue more to entertain the PILs. When it comes to the knowledge of the court, yes, there is an issue which required to be looked into. PILs are registered. We have Article 39A of the Constitution, which requires the state to have the act, the scheme for providing legal aid. That's also a part of facilitating access to justice. We have state legal services authorities, district legal services authorities. Mr. Mishra is coming, probably I should cut short. So we have state legal services authority, district legal services authorities. We have taluka legal authorities. Those who are in jail, not aware of their right to file an appeal, these authorities, they help them. Coming forward, they provide them. Paralegal volunteers are there. These paralegal volunteers, they help them. They spread the awareness not only about the legal rights, but about various beneficiary schemes which are floated by the governments. So that is also a part of it. Then, first session we have seen technological, court technology. We have now live streaming, virtual hearing, virtual courts, then video conferencing, hybrid mode of hearing. We have seen the lawyers from far off places appearing in the courts. This is access to justice. We are coming up with the artificial intelligence. We have apps where if a litigant wants to know the status of his case, he can immediately put the number and get the results. That is access of justice. So we have problems, there are solutions. Every court, in fact, every high court has now IT team. They are working on improving the system in the high court. So efforts are being made, and I'm hopeful that the system theoretically which exists, which I told you about, giving the Jahangir's example, that will be transformed into practicality, and we will have that kind of transparent and direct access to justice. And that's what I wish. Thank you.
Thank you very much, sir. Sir, your words are a manifestation of the fact how humble, compassionate, down to earth, and scholarly virtues you are endowed with. Thank you very much, sir. Now, for the next session, which is our last session, I would request the Honorable Chairman, Bar Council of India, Shri Manan Kumar Mishra, to escort Honorable Justice Jitendra Kumar Maheshwari, Honorable Justice Ravi Malimath, Honorable Justice Vivek Rozia on the stage. Mr. Prabhakaran, our Vice Chairman, please come on the dais. Mr. Apurva Sharma, so we begin our last session, the valedictory session. I request Honorable Justice Vivek Rozia, Administrative Judge, High Court of Madhya Pradesh, Indore bench, to please come and share his views.
Dignitaries on the dais, off the dais, a very warm good afternoon to all. Today we are here on the seminar on courts, technology and access to justice changing perspective. As the word changing perspective itself suggests that the change is the need of an hour. I would like to quote the word of famous baseball player, Mr. Yogi Berra, USA. He says that if you don't know where you are going, you might wind up someplace else. So we should take technology in the right direction and use the same for the right course of action, which is very important for the sustainability of the system. Being a member of E-Committee of this High Court, I would like to inform you all that what we are doing and what we have to do in this technologies. The High Court of Madhya Pradesh has taken various initiatives with the help of technology for the litigant and the stakeholder for easy access to justice and some of them are. As you all know, our IT team has designed and developed an official website of the High Court of Madhya Pradesh, in which all the information about the judges, committees, gradation list of judicial officer, case status, daily cause list, recruitment process, advertisement, everything is there. Now, we have also developed a computerized listing policy. CMIS software developed by IT team of our High Court is working efficiently for last 6-7 years in order to meet the ever-increasing demand for the listing of cases daily with the limited judges in this High Court. The second task was the computerized cause list. As you know, the preparation and distribution of the cause list to the lawyer by a bar association was the biggest problem. And in courts, there used to be a ground for adjournment that today we have not received the cause list, our cases are not published in the cause list. Now that days has gone. We prepare a cause list in advance and publish in our official website. Each and every lawyer gets an information about his cases listed the next day. Another problem which we are facing is the certified copy. There was a huge burden on our cause list section for delivering a certified copy within time. Even that problem we have solved it by introducing e-copying modules. Now anyone from any part of the country can apply for certified copy and he will get the copy through his mail, and that is treated as a certified copy. I would like to inform you with proud that work of scanning and digitization which we have done. As on 31st April, the scanning and digitization of the 44.5 lakhs file comprising 17 crores pages we have already scanned in the High Court. And likewise in district courts, 35.82 crores pages have been completed at 52 locations, including 46 districts. So because of this scan and record, we could work during this corona period. We have worked from our residence with all the files, scanned file. We never call any physical file to our houses. Thereafter, we have worked on virtual hearing of the cases function in the less paper mode. Implementation of the secured Wi-Fi internet. High Court of MP has taken an initiative to implement wireless secured network solution in all the benches and district courts. In phase 1, High Court of MP and the benches at Indore, Gwalior have been enabled with the secured Wi-Fi network solution with 122 Wi-Fi access point. And this Wi-Fi facility is available not only to the judges but every litigant, lawyers free of cost. During the second phase of the High Court of MP is going to provide the secured Wi-Fi network solution to all 50 districts. Thereafter, I feel proud to inform you that the High Court of Madhya Pradesh is the first in the country to integrate the CIS software of district courts with the respective government departments. So, Bhu Abhilekh, and now today you can check every land record by inserting a khasra number. You will check whether any litigation is pending in respect of that land. That will reduce the multiplicity of the proceedings in the court. Even while taking that Rin Pustaka for bail matter, court can check it whether this Rin Pustaka is a forged document or not. Now we have developed a dashboard and auto electronic mail system. In this, all digitally signed orders, judgments passed by this courts are being sent through automatically email system to the respective departments, courts, jail authority for faster compliance. All the government department can view their cases in our official website in order to prepare them a reply before the notice was served to them. We are also working on an integration of e-court services with Lok Seva Kendra. The integration of e-court services has been completed with the government of MP through Lok Seva Kendra by our IT department. E-court services like inquiry of cases, status, online application, status, e-filing of petition, purchase of stamp, payment of court fees, all are possible through e-Seva Kendra. Next is computerized web conferencing solution for the High Court and District Courts. All the 3 benches of the High Court are connected to each other through web conferencing. Now we are conducting our full court meeting on an urgent matter through web conferencing. Meetings, various committees are conducting meetings through web conferencing. That saves our lots of time, money, traveling, etc. The advocate can develop their e-office through our website. Advocates are allowed to create their login ID and password on the official website of the High Court for their cases registered in the High Court. They need not to maintain a diary now. We have started the National Service and Tracking of Electronic Process, NSTEP, under which the District Court and Tehsil Court, with the help of smartphone summons, are being served to the parties and accused. We have provided 1,000 smartphones to our Majkuri and process servers for the services of summons. The High Court of Madhya Pradesh is the first in the country to extend the video conference facility to all the district hospitals, juvenile boards, railway courts, family courts. Till 31st March, from the fund of the state government and e-committee, 1,953 numbers of VC system have been purchased and installed at the district and tehsil courts. The district judiciary has conducted approximately 7 lakh VC till 31st March 2022. The percentage of appearance through video conference out of actual appearance in all 124 jails is more than 90% now. We have provided laptops to our all judicial officers, right from civil judge to High Court judge. Now we are working on an e-court phase 3. The vision document has adequate provisions to deal with the upcoming need of court. All the stakeholders like police department, jail, investigating agency, public prosecutor officer are going to be connected with each other. The live streaming of the court proceedings are not now unknown to you. You all know how we are working through live stream. All can watch the court's proceeding through YouTube. At this point, I would like to thank Honorable Justice Satish Sharma and the then Chairman of E-Committee of the High Court and now the Chief Justice of Telangana High Court. And also thank to Honorable Justice Rohit Arya, Chairman of E-Committee. Under their able guidance and support, the High Court Jabalpur has taken various initiatives for the litigant and public at large. Under the able guidance of our Honorable Chief Justice Shri Ravi Malimath ji, we are working on our ambitious project, Courtroom Live Audio Visual Streaming System and Integrated Surveillance System project that will enable live streaming of every courtroom from all subordinate courts under the High Court. Entire country is watching how we will start this project first. So we are already working hard on this. Now there are some suggestions for that betterment of technology and e-services. Robust high-speed network connectivity through dedicated network. Backup support connectivity for the network. And computer-based training room in each district courtroom. Next, data backup to keep at the disaster site with a proper automated data backup, recovery machines and visualizations. The facility of e-library at central level in order to create a knowledge bank and data bank. Collection of biometric data of all the accused under trial prisoners to know their criminal antecedents and period of custody in their jail. The FIR number is to be generated on the centralized basis in order to maintain the uniformity of the data. After computerization, the steps are liable to be taken for minimum use of the paper in the courts to develop the software like e-memo system, e-circulars that may lead to a sustainable development towards the green environment. Some of the upcoming ongoing projects of the High Court, the courtroom live audio visual system, as I told earlier. Setup of information technology command and control center at High Court of MP. Implementation of software of online preparation of the postmortem and medical legal report. Development of machines and seamless e-payment with the State Treasury Department for various deposits. A smooth operation of criminal justice system, ICJS, and the data sharing between all the pillars of the ICJS. Next is implementation of the virtual court for traffic challan management and other petty matters. E-Seva Kendra at all Gram Panchayat in the state of Madhya Pradesh. Availability of the e-services to the litigant, advocate, and other stakeholders through MP online kiosks. Installation of face recognition based biometric identification system in the High Court, through which now the accused who have been granted bail can mark their presence without disturbing their lawyer and without creating any burden on our staff. They can mark their presence in their respective districts court also. They need not to come to the High Court for this purpose. Now, one new system which we are going to introduce is a QR code system. Now, at the time of filing of case, we will generate a QR code system that will work for file tracking system. Now, after scanning this QR code, any concerned clerk or DA can find out where, in which section, which code this file is lying. So that will track the entire system. And now for feeding any detail in the system, he will have to just scan from his QR gun and that case will enter into his system. So that will eliminate all the register, and our IT team has given a slogan that "Ghanto ka kaam minto mein." We have integrated ILR data with MP our website. Now each and every AFR cases, if it is reported in IR, that our High Court website, you will get information. It is reported in MP ILR, MPLJ or SCC. So you can directly take out the print from that. The digitalization and integration of IL record, I have said. Now online, we are connected with the SCC online web also. So our ILR systems, cases are also shown in the SCC online as well. So this is, we have done, and we have to done much more. And under the able guidance of our Chief Justice, we are all doing. Jai Hind.
Sir, thank you very much for sharing with us the concrete and formidable steps which are taken by Madhya Pradesh High Court in the digitization drive. Thank you very much, sir. Now I would request our chairman, Mr. Manan Kumar Mishra, to present a memento to Honorable Justice Vivek Rusia. Now I request Honorable Justice Ravi Malimath, Chief Justice High Court of Madhya Pradesh, to share his views, and thereafter our Chief Guest Honorable Justice Jitendra Kumar Maheshwari, who we are waiting so patiently to hear. Thank you very much.
There will be a photo session also. So
and thereafter, there would be a photo session in the last with the Bar Council members and students. Thank you.
Good evening to everyone. In this valedictory session on the Symposium on Courts Technology and Access to Justice, Changing Perspectives, I would like to focus my address on access to justice, since I have spoken on courts technology in the morning. What does one mean by access to justice? There are certain aggrieved people in society who are unable to approach the courts due to various reasons, such as financial constraints, by virtue of being unaware that they have the right to approach the courts to resolve their grievances, or because they do not trust the courts or the advocates. Access to justice is when each of these are appropriately resolved so as to enable the aggrieved person to approach the courts with confidence. The onus of ensuring that as many people are provided access to justice as possible is both on the advocates and the judges. On the judicial side, it goes without saying that delivering justice and fair judgments by a judge goes a long way in impressing upon people that justice will be delivered without fear or favor, affection or ill will, and that there is no rich or poor, male or female, no religion, no region. There is only a petitioner and a respondent. Judges on the administrative side, through the State Legal Services Authority, attempt to provide quality legal aid to the economically weak or the marginalized sections of society. The process begins with identifying people who require legal aid, including identifying people who are unaware that they are eligible for such legal aid, educating them about their rights, informing them of the legal remedies, and subsequently providing them with appropriate legal aid based on their requirement. In this regard, advocates have a major role to play when it comes to access to justice. Advocates can proactively reach out to those who require their assistance. They can instill confidence in those who hesitate to approach the court of the aggrieved's ability to get justice, and also assure the aggrieved that they would strive for their case. Some advocates have undoubtedly begun accepting pro bono briefs, and those advocates who have had a history of arguing pro bono have increased the percentage of such cases. There are non-governmental organizations operating in this space as well. This notwithstanding, due to the absence of an institutionalized and mandatory pro bono imposition, the onus is on the advocates to willingly come forth and provide their services. Mandatory pro bono impositions may not work as effectively as one would expect them to. If an advocate reluctantly takes up a case, he may not be inclined to put in the hard work and provide the time that is necessary to win the case. He may instead prefer to devote his time to a case for which he is receiving compensation. Though there are exceptions to this, generally, if pro bono was to be made mandatory, there are chances that the client would be at the losing end because of the lack of requisite commitment from the advocate. It would be unjust for a client to forego his rights just because his advocate consciously failed to perform his duties. Therefore, the advocates must voluntarily and happily take up pro bono cases or refrain from accepting such briefs. Once a pro bono brief is accepted by the advocate, he must treat such a brief like any other brief for which he is receiving his fees. This is not to suggest that advocates should endure monetary hardships themselves or go out of the way to accept such briefs, but when you are in a position to provide assistance to those who are not as fortunate, you should definitely do so. Some advocates may wonder about the benefit that they would receive if they took up a pro bono case. There is no monetary benefit, but the happiness that you feel when you secure justice for your aggrieved client would surpass any monetary benefit. Even if you do not win the case, the knowledge that you have strived for your client is sufficient. Those of you who had undertaken pro bono cases would relate to what I am saying. Winning and losing cases are a part and parcel of an advocate's life. Winning any case is special, but winning for a client who has nothing to offer you in return but his gratitude is indeed unforgettable. Apart from the role played by the advocates and the judges, access to justice is also greatly enhanced due to the presence of good infrastructure. Both physical and technological infrastructure for courts across the state is imperative. At a macro level, for instance, the establishment of benches, establishment of courts at various districts are principally for the benefit of the litigants and not for the judges or the advocates. It is so that the litigant do not view distance as an impediment to file a case. At a micro level, the provision of basic facilities in the courts are essential so as to ensure that the litigants are not deterred from pursuing their case. At this juncture, the thoughtful initiatives introduced by Honorable Justice Maheshwari are indeed very commendable. To conclude, successfully widening the ambit of those who have access to justice is a continuous process and would involve efforts by the judges and the advocates, and also necessitates the presence of good infrastructure. I congratulate the Bar Council of India for the successful completion of the Symposium on Courts, Technology and Access to Justice, Changing Perspectives. I do believe that the advocates have benefited from listening to all the honorable speakers today. It is always a pleasure to be at Indore and interact with the advocates here. There are many experienced seniors and promising juniors here, which I can say by experience of hearing them. And I really look forward for further interactions with every one of you. Thank you.
Sir, thank you very much for highlighting the various facets of the regime required for facilitating access to justice, and particularly the role of advocates for achieving this pious job. Now I would request our chief guest, Honorable Justice Jitendra Kumar Maheshwari, to deliver the valedictory address. Thank you very much.
Let us give a big standing ovation to the son of the soil, Honorable Mr. Justice J.K. Maheshwari.
Dignitaries on the dais, off the dais. I have also decided I should not make any mistake now, naming anyone. We have to go in short, abbreviations. Friends, today we have inaugural session, first session in courts technology, and the second is access to justice. Various views have come. I will tell you about those points, challenges and way forward. Prior to that, I will quote recently our Prime Minister on the technological advancement in the court in a speech quote. I quote so: convergence of technology and the judicial system is the need of the hour. We need to go digital and adopt online analysis of legal cases. Dissemination of legal knowledge to the common man will also go a long way in improving the law and order situation in the country. We can understand today in the context of the topic, courts, technology and access to justice, changing perspective. Since morning we were hearing that how this access to justice started from the history, how it has come pre-independence, how by the Supreme Court, I can only add one thing in this, otherwise you could get everything. That at the time of our independence, when the Universal Declaration of the Rights were there in 1948, the history which was from the time of the Jahangir, Quit India movement, has been recognized. And at that time, it was said, universal recognition as a right to an effective remedy before the competent forum for violation of the rights vested with an individual by law. So it is recognized there. In our country, Supreme Court of India gave so many judgments recognizing this right, has said it emerges from the Constitution. Constitutional debates also discuss all this. Just now, we see the facets. Justice Ravi Malimath has told that how and what manner he started inducing manner access to justice may be dispensed. At the time of courts technology, when he was speaking, he requested for curtailment of the adjournment. What is the impact of mannerism and its curtailment? Suppose we go by a technology, we adopt a technology, it should not go in vain. It is one of the manner by which the access of justice must be provided to a needy person. On the point of courts technology, I want to show you some data. During pandemic, by virtue of this technological advancement, no doubt, as was discussed, whenever there is a need, there is invention. E-Court project, which was started initially since 2004, actively taken into consideration 2007, then in Madhya Pradesh in 2013, there was a need. But at that time, nobody had thought of it, that we will have to go virtual hearings, and such a situation as arose during the pandemic would come. So, the need came how the justice can be dispensed and how a people can access the justice. This system we know, as my previous speakers have also said, it is for the needy person who is looking for the court. And we are the part and parcel of the same. I remember poet Rahim said, दीन सवनिकों लखत हैं, दीन लखे न कोय, जो रहीम दीन लखे, दीन बंधु सम होय. And you will find in the court of Madhya Pradesh, in so many courts, this code is written. It is my study. I have gone in some of the courts. I found this is written. So we are working to the needy, to whom this access of justice is required. So I want to show, I was on the point, that by way of a technological advancement, what has happened, some data are available to me, which I will quote, and it is for encouragement for all of us, nothing with respect to challenges and way forward. So those data are statistics by the court all over India. Through video conferencing during this period, we have heard the cases as on 28/2/2022. Those cases heard by all court were 1,23,19,1917 cases we have heard by way of virtual mode. High courts have heard 61,02,859 cases, while Supreme Court heard 2,18,891 cases. In Madhya Pradesh, what has happened? I want to show. As on 28/2/2022, in Madhya Pradesh, the cases heard in High Court were 6,37,396 by virtual mode. In district courts, 6,73,671. You will find the number is less. Here it is a point of advancement and changing perspective, what we can do. And that is the position of the data. Now this data reflect that at High Court level, the virtual hearing mode we have done more effective than subordinate courts. This is a point to think how we have to improve the functioning of the subordinate court by way of technological advancement. The data further says in High Court and Supreme Court, it is 80% cases can be taken up, but in trial courts, only 27% cases or 27% people could have been benefited during this period. So this is one of a alarming situation on which we have to work out. Now I am coming to the challenges. What are the challenges we have? And in those challenges, one challenge which I know during this pandemic, pendency of the cases have been increased in the courts. We have to think by this technological advancement, can we do something thereby we come on the same position within some reasonable time to reach up to that situation with the same paraphernalia and same persons. We have to think this part. The problem which is being faced simultaneously are manifold. As discussed or as said by our speakers, we have enormous digital device and differential access to technology infrastructure. Another, lack of digital literacy in the litigants advocate regarding use of e-court facility. Lack of consistency of service providers for similar platform across court for virtual hearing. This is the problem faced by everyone and known to everyone. Then lack of judicial infrastructure. In Madhya Pradesh we have developed. We are discussing on the platform of the Bar Council of India. So we have to think that what we have to do, thereby the judicial infrastructure can be increased. So these are certain points on which we have to work out, in addition to the fact that lack of awareness of the large proportion of the judges, court staff and advocates. I put a question to myself always. Whenever we provide a training to our judges,
training institutes are there, but what about advocates? Until fair competition would be there, can we develop? We can only develop when we have our competitor and we find how I should prove better than that. So we have provided training to our judges. We have provided all facilities, all softwares to our judges. Are to that extent, those facilities are available with the advocates. They have that much trained, or for their academic development, advancement, any programs are there? My request, I always appeal to the Bar Council of India as well as to the State Bar Council, whenever I am in a speech, that please provide some platform. The High Court is providing a platform to the advocates to go for a training. But in those trainings, we find some of the advocates are not coming and attending. The reasons I know, I cannot express, you know better. What are the problems? But please don't go for earning for future. Earn today. Earning is not a money. Earning is a knowledge also. Please earn it. This is my humble request to all of you. When you will earn a knowledge, you will earn the money, but you have to go for these technological advancements and trainings. So this is one of the aspects that is required to be done. We are discussing about the technology advancement, but simultaneously, during this period, what I have seen, the young boys who have come from 5-year law courses, technologically sound, they were benefited during this period. But what about other advocates? What they have done during this time? Can we not provide any platform to those persons being a bar association members? At least we should have provided 5 to 6 stations everywhere in every bar room. Whether we have provided, we have every Indore is having the e-court library, 2-3 e-court libraries here. We can provide there, but we have not think of it. We have to think those persons can also compete, those persons can come, but we have to give them a platform. We have to think of it. So far as access to justice, would it enough that a poor person, needy person is coming to you and he says, this is my case, you prepare it whatever in manner in which you want to prepare, submit it to the court, court allowed or dismissed, whatever it is. Suppose it is dismissed, and at the time of dismissal, all his rights with a legal position has not been put before the court, would it be excess of justice? I always say to the advocates, you know why this black color and white band? The black color indicates of a firm determination and white with a peace. There is a history behind it. There was a Roman emperor where when he was doing the justice, his law was, suppose anyone come forward to support the other, and if he not succeeded, the punishment which is to be provided to that person, the same punishment to the person who has come forward to assist him. This was a law. Same situation came. One man stood up and said, no, I will support this man. King said, you know what is the rule of this kingdom. That man said, I know if I could not succeed to defend him, I will have to face the same punishment as he has to face. Yes, Even then you stood up. He come with the black kafan on his head and said, okay, this is my determination to say a right thing. So this was a commitment with the advocate, but white is indicated with a peace. So therefore, you are in the court of law demonstrating this much. Now, in excess of justice, I was discussing, when a brief has come to you, you could not prepare it thoroughly, submitted in the court, and that man loses for your fault. Is it an excess of justice? So, this is a need where we have to work out, and are we doing? We have to think in addition to other things also. The same thing applies to the court also. When we see, no, we can do something, we can give a justice. And you always know, whenever I was sitting in either in Indore or at Jabalpur, if the person is having a point, I myself has indulged into that and tried to help. It do not mean that I am helping that man. I am doing justice, and it's a way forward to access to justice. So it ought to be done. It's a either way. This is not a one side. I am not saying, I am not a preacher who can say, okay, advocates should do that or should not do that. I am not nobody. But these are the food for thought. So this is a point in an excess of justice. So we have to think on it. Now, while all around discussion of this, what I found during 2 sessions discussion, Justice Menon said, we are working in a court. When you go to the tribunal, now the court is developing, they have all facilities. Needy and poor person can come and put by way of digitalization in their cases in the court, but when they go to the tribunals, they don't have all this facility. But they have to take a recourse under the statute before the tribunal. They cannot go here and there. So, what we are doing, so BCI's request they have made. So, this is one of the aspects which Justice Menon has highlighted simultaneously with other issues on the point of disparity. You see, Justice Ravi Malimath has come on the point of courts technology. Justice Ravi Malimath said, started with the word of caution. We have to see the utility. What's the utility? Going for a technological advancement, first assess the utility, because if it is not helpful, it is not of useful, not of utility, can we go off this? So this is a word of caution. He started from that, and thereafter, whatever we are doing, what is about adaptability of it? Is it adapted by one? I discuss about the advocate situation. Adaptability, they were feeling that in these days we have to go virtually, but they were not having that much assistance or technological advancement. So adaptability in technological advancement is one of the thing. Then third thing, what he said in the point of adjournment is use it, don't use for the purpose of adjournments. This was his version, what he want to say. So I want to convey, I have seen some change in the functioning of the high courts,
as well as in Supreme Court. That I would express you. Probably it may give a point for thinking to everyone, even to the judges, Chief Justice sitting here of 3 courts, as well as the advocates. What is happening there? There 2 Monday and Friday, you everybody know, there's a miscellaneous days. In those miscellaneous days, the new cases are being listed, and others, some cases in which the notices have been issued, those would be listed and that would be heard. My experience there is, the 40 cases are listed. Out of them, 25 is new. You will decide 25. Means 10 goes. All right, 10 to 12 goes. 10 to 12 notice. Then remaining cases in which if the response has come, counter affidavit has come, we will hear on that day. And in other days, Tuesday, Thursday, Friday, Tuesday, Wednesday, Thursday, those cases which are listed, out of them my experience is more than 50% cases are being heard. They are not being adjourned for region or until a letter is circulated that it should be adjourned. So that is the situation. If we can apply this, because the number of pendency more here, I can understand the practical aspect also, but we have to apply to some at least for 1 or 2 days for this purpose and take up the hearing matters. So this is one of the aspects, thereby use of technology can be done. Justice Sharma said, what is tangible, non-tangible utility? Again, it's a point of utility. Issue of linkage he has pointed out. This is one of the point which is in the way forward, and we have to work out on this with the, and write to the government, with the assistance of the government, we have to do it. We have all broadband and everything facilities. Even then, if we go to the trial courts where the electricity are not there, the judges are not in a position to work. Internet facilities are not available that much as it is required for the purpose of the hearing. So these are the certain points which he has said. In addition, he said what we have to do and what the Madhya Pradesh has done, because he was the chairman for a long time here of the E-Committee. In the second section, the theory of excess of justice has been discussed, and our judges have described in detail what is access to justice. I say, in addition to all those theory, wherever we think that we are not in a position to get the justice from court of law. I'm talking of court of law only. Court of law, how remedied can be made our system, it is access to justice. And finally, you have seen that what development has been done by the Madhya Pradesh. We should be confident of it, but we should not think that we have done a lot. We should be confident that we have done better than others, and we have to make a commitment today. We'll do further a lot with a commitment, thereby we will go ahead. So now these are the overall discussion of today, and in discussion I found certain issues which is to be forward. Number one, improving the infrastructure for judicial officers of the district courts and subordinate courts, as well as advocates. How it is to be done, that is one point. I said it's a pressing need to the bar councils, states or the local bar associations that they should impart training to our advocates, and if needed, the request may be made to the Chief Justice of the respective High Courts to provide training, basic training, thereby for the technological advancement, for the adaptability, the advocates must coincide with the procedure and way forward for the access to justice. In addition to the same, the active participation, promotion and patience by all stakeholders of the legal fraternity is required. It may be any one legal fraternity simultaneously. Thereby what would happen? By this we can develop our society, and the people of in these days who are coming from far-flung places, they are unaware of this technological advancement. By the help of those persons, at least they may come forward for the same. I requested that for the need as arose for 2.5 years, and still at some places it is going by the virtual mode. For some cases, the centers must be provided by the Bar Council or the local bar association. Training for paralegal volunteers at village level for awareness is required. And finally, and the most important, is uninterrupted electricity supply and connectivity. If that can be possible, then by way of technological advancement, by the help of the same, access to justice may be more easier than other. So we have to work out in one tandem with the help to do the needy persons and to work with an intent that by technological advancement and by changes, we have to provide the access to justice. Our thinking must be, at last, I will quote and I will take my place. Our thinking must be access to justice in a digital world is about building a digital world for access to justice. So digital world for access to justice, we have to think like this. And with these words, I conclude my speech, and I am grateful. I will not thank, I will be grateful that Bar Council of India Chairman and all the members of the State Bar Council have called me for sharing my views with all of you, and at least gave an opportunity thereby I could meet with everyone here. Thank you very much.
Thank you very much, sir, for the thought-provoking and soul-stirring views expressed by you, and particularly the views about advocates' role in the justice delivery system, the issue of lack of training for advocates. We have a judicial academy almost in every state in the country, but there is no lawyers' academy. The government has never thought about it. Bar Council of India has taken a lead, and Bar Council, and I will request our chairman, Mr. Manan Kumar Mishra, he will throw a light on this, because the Lawyers Academy is so necessary in the present perspective and the present circumstances, particularly the issue about training in this digitization and this VC system. It is highly necessary and required for advocates. In every state, we are trying to open this judicial lawyers academy. We have already started the work in Odisha. The building is under construction. In Goa, we are going to start very soon. The chairman will throw a light on this. And after that, Mr. Prabhakaran will propose the vote of thanks, and thereafter high tea.
My Lord Mr. Justice J.K. Maheshwari ji, the chief guest of today's function, we are really thankful to you, sir, that you have highlighted the need for training to the lawyers, for the kind information of all. The Goa government has allotted 50 acres of land to Bar Council of India Trust, and my Lord Mr. Justice Maheshwari ji, I don't know the office has informed him or not, but he is a part of the trust of Bar Council of India, and we are going to establish not only international law school but a huge training center for lawyers, and we are going to frame a rule in which for the young lawyers the training will be compulsory unless in the period of 5 years for at least 15 days they don't undertake the training courses, their certificate of practice will not be renewed. So sir, we will need your guidance, your cooperation, your blessings. Whatever you have said, we have noted it down and will be abide by your opinion, your verdicts, whatever it may be. Thanks. Thanks to all.
Now, Prabhakaran ji to propose a vote of thanks.
Dear members of the bar, since morning, 2 sessions completed. Now we are in valedictory sessions. First, I have to thank Mr. Menon ji. He has taken a very task. When we had discussed last 3 occasions, the problem past 2 years, in a pandemic situation, the members of the bar has faced a lot of difficulty. Our movements have been restricted. We are not able to move outside. But the courts are functioning. How? Then we have no other option. We have faced the virtual courts hearings through online. Today the Honorable Justice A.M. Khanwilkar and Honorable Mr. Justice J.K. Maheshwari ji has expressed the court's technology and the access to justice. As far as access to justice is concerned, only one word I can say that: knock the door, justice to your doorsteps. That is the principle everybody has followed. But the court's technology, don't mistake me what I have been trying to say here. Please, Mishra ji, we are living in a city, particularly myself in Chennai, and then many number of lawyers in Delhi and Mumbai, in everywhere. We are able to access through online connection this and that. But members of the bar, mostly 80% members of the bar, practicing in rural areas, they face a lot of difficulties. Then thereafter the Bar Council of India has taken a steps. We have written a letter to the CJI. We said, please kindly start the physical hearing. Even 2 days back, myself appeared there. Number of lawyers, even if it is a Friday, virtual hearing also permitted, but the many number of lawyers in the physical hearing present in the court. So therefore, the access for all issues, the physical hearing is a feasible one. But here, your Lordship has very clearly said how to, step by step, we have to improve the court's technology, and particularly in this symposium, Lord, I have to thank the Honorable Mr. Justice A.M. Khanwilkar. He has expressed his view in a very fantastic manner. The Honorable Mr. Justice J.K. Maheshwari ji, as though he is a son of the soil here, he knows about the Madhya Pradesh situation, and he expressed what and all the development stature has been taken place here, that also I express the members of the bar. The views have been taken by each and every one of the young lawyers. Sir, as far as that, you have given a beautiful and excellent views about the court's technology. I thank you, Lord. And I thank the Justice Satish Chandra Sharma, and I thank Honorable Mr. Justice Prakash Shrivastava, and I thank Honorable Mr. Justice Prashant Mishra ji, and I thank Honorable Mr. Justice Rajendra Menon, and everybody in their valuable times. And they had a lot of work, even in that situation, today participating in this symposium. In the morning, all 4 sessions, 2 sessions plus seminar, inaugural session and the valedictory session, you had been just sat here and expressed your view. As far as the Bar Council of India is concerned, I am very grateful, thanking you, all the lordships. And in these sessions, many number of Bar Council members throughout the country, some Kanyakumari to Kashmir, all the president, all the chairman of the state bar councils, vice chairman of the state bar councils, some of the executive chairmen and co-chairmen have been participated here. I thank each one and all. And then the honorable judges of this great high court, the Indore bench, many of them has been participated and listened whatever the judges have said here. And each and every one of the, I'm not able to mention the name, so each and every one of the members of the bar and leaders of the bar who are all participated in these seminars and even in the valedictory session, you have observed everything. So your observation definitely you will have a very effective, the professional indicates whatever you have to step one by one. We cannot have every day to explain everything. The Justice J.K. Maheshwari has said, what are the hindrances in our profession? As far as the technology is concerned, we are not yet reached to some extent. Absolutely, the online connectivity is a more problem. Many of the persons, the members of the bar, even still they are having the cell phone and they are conducting cases. So in this situation, please each and every members looked into what is the step-by-step you have to go. So therefore the Bar Council of India, I have to mention each and every member of the Bar Council of India has cooperated with this, and particularly I have to thank Mr. Pratap Mehta. He said you have to conduct the program in Indore. Then immediately the Manan Kumar Mishra has been agreed, yes, you conduct. They're really the very nice ambience and very excellent place we have chooses. We organize the members of the Bar Council of India, particularly Manan Kumar Mishra ji, you conduct a program here. I request you please conduct the program in Chennai also. So therefore, so each and every places, see, I have to say only one thing. I'm very happy that such a person being a chairman of the council, he never get annoyed in any members. He will, whatever the members will say, he will accept. Yes, I will agree. So in that aspect, definitely each and every state will have the same type of the inaugural and all the sessions, and everywhere we will get it. So don't worry. I thank each and one of the members of the bar and each and one of the leaders of the bar and each and every all the state bar council leaders. Thank you very much.
Sir, kindly see the punctuality. We have seen, we have closing the program right at 5 o'clock. This is the time. So, we are so delighted to share with you that the program has been finished within the time limit. Now, I request all the honorable guests to join us for a high tea. Thank you very much.
All the honorable members of different state bar councils, they are requested to be here for a photo session, and we have a memento and a shawl for them. तो जो लोग हमारे स्टेट बार काउंसिल के मेंबर्स आए हैं वो यहीं रुक जाएं. ऑनरेबल गेस्ट्स को अभी हम थोड़े देर की छुट्टी देंगे चाय के लिए, और फिर डिनर पे हमारे ऑनरेबल चीफ गेस्ट साहब रहेंगे. ऑल द ऑनरेबल जजेज ऑफ द हाई कोर्ट, they will be there. The honorable members, guests coming from different state bar councils, they will join us on the dinner. हाँ, अभी तो हाई टी के लिए जा रहे हैं.